This is your last chance. Kill the children so you can kill yourself. That's not me being dramatic. That is a direct quote from a court filing describing the voice inside Lindsay Clancy's head on the afternoon of January 24th of 2023. A loud, demanding, repetitive male voice. And according to her doctor's own records, it had been screaming at her for weeks. You will never be the same. The only option is to die. She told her providers about the voices. She told her husband. She told her mother. She went to emergency rooms. She called a suicide hotline and was told there was no emergency because she didn't have a plan. She admitted herself to the #1 psychiatric hospital in America and didn't see a doctor for 3 days. 12 medications in 4 months, 4 prescribers who never spoke to one another, 2 textbook red flag reactions to antidepressants that, according to the civil suit that her lawyer just filed in January, should have told any competent psychiatrist exactly what they were dealing with: bipolar, postpartum onset. Nobody caught it. And on January 24th, while her husband was out picking up dinner, that voice gave Lindsay Clancy her final command. She strangled Cora. She strangled Dawson. She strangled Callan. Then she tried to follow them. She survived, paralyzed for life. Now she's charged with 3 counts of murder, and her defense will ask 12 ordinary people to do the hardest thing the law ever asks: separate what she did from whether she was legally there when she did it. Tonight, we're breaking down the 29-page civil suit. Let's dig in. Good afternoon and welcome to Defense Diaries. I am Bob Mata, and as always, I'm joined by my beautiful and brilliant co-host, still not in her normal place, Allie. What's up, girl?
Hey, babe. Hey, all. And today is Thursday, July 16th, and I think you can tell from the cold opening that this is a going to be a hard episode to listen to, so these are your trigger warnings.
Yeah, consider yourself warned. If harm befalling children of the worst kind is something you cannot handle, this is not the live for you. It is not the live for you. This is an incredibly difficult case to talk about. It's going to be an incredibly difficult trial to watch. Any parent, any human being that's out there is going to struggle with it. But it's such an important case. This isn't, from listening to Allison and I, mental health is incredibly important to us and how it's viewed in the legal system or not viewed or treated within the legal system. This case is so incredibly important that I hope that everybody watches it. There's no case in America that's going on right now that's more important than this case. That is starting with jury selection on the 20th, next week. They have no idea how long it's going to take them to pick a jury. The judge is allowing for 18 jurors to be selected, 6 of those being alternates. They're going to get increased amounts of challenges because they anticipate it's going to be a very, very difficult jury to select. So how long that's going to last, who knows?
And just to flesh that out a little, when he says they're going to get additional challenges, both sides jointly requested, and the judge agreed that they should have more preemptory challenges, meaning they can strike a juror for whatever reason, which will, of course, make it even take more jurors to go through possibly to find a jury pool. But as Bob said, that goes to show that everybody, realizes this is going to be a challenging jury to seat, and the possible issues and biases that the lawyers are going to be looking for run the spectrum more than your average. So they're giving them those extra preemptory challenges.
Yeah. And so this is our game plan for the day and how we're going to handle this. We consider this to be a primer. We're going to start with the affidavit. Okay. And I'm talking about the probable cause affidavit or affidavit for a warrant. That's going to give you a pretty good background of what the state has in terms of their case. And as we kind of dig into that, it's going to become clear to you that the state's position, if we're going to bottom line it, is that because she was able to plan, because she sent her husband to the furthest restaurant that she could think of that would allow for her to have the time to do this, that clearly she's in her right mind legally. And we'll talk about it when we get to it in terms of the difference between a clinical or medical diagnosis of insanity and the legal one. They're very different things. So after we get through the affidavit, we're then going to shift over to the jury instruction for the defense that they're going to be employing. There's no better source than to go to that to show exactly what the state's burden is here in terms of what they have to prove in order to get a conviction on this thing. And then we are going to slip into Rosemary Scapicchio's lawsuit that was filed in January of this year, suing all the doctors, all the medical providers that completely abandoned this woman.
No pharmaceutical companies?
Maybe. I don't know. I mean, like, that's a different lawsuit. That's a different lawsuit. You have 4 doctors that weren't talking to one another that were all prescribing her shit. The lawsuit is a fabulous way to understand exactly what this defense is going to be and why it matters. This isn't your normal case. I can't remember a case like this. These insanity defense cases, and they don't call it that in Massachusetts, which we'll get to when we go through the jury instruction, are, to me, just so confounding because of people's inability to appreciate mental illness in this country. Like, people don't, like, I think people have a misconception that if you're psychotic, that you're psychotic 24/7.
Right. That you're just running around talking to the walls and screaming at the floor. And that's the only type of psychosis that exists. That is what the law wants to see in order for psychosis to mean something in the law. And maybe this is a case that's going to help reshape. And I know you said they don't call it insanity, but just the insanity defense law, the things of that nature, because, in almost all states, compulsion is not, an insanity defense based on compulsion, that you could not control yourself to the law, that you had no ability to control your conduct, doesn't exist. And if you think back, all right, to Gacy, to all the other serial killers, they very likely have a type of compulsion, but that's not this type of compulsion. That's not, medication and failed doctors and the end result being hearing voices in your head compelling you to do something. That is you've been wired wrong, and it feels good. So you've got this internal compulsion, right?
Yeah.
And the law needs to find a difference in that. And look, I have to say, postpartum depression, postpartum psychosis, it is not alone in this issue. This is an issue that all people with mental illness suffer, but where it does differ is the thinking, especially of men, and I'm sure some women as well. That you say postpartum depression, like, oh, come on. Are you fucking kidding me? Oh, sounds like the Twinkie defense. That is where this case is even more difficult than just people understanding that when you have emotional instability in your life, and you're having, that's having an extreme impact on your life, that once they start to prescribe you medication, that can shift for the extreme way worse. And that's something that men, women, children have been suffering with since all these medications have been about. I mean, Bob and I, 20 years ago, probably the first year we're practicing law, I filed a lawsuit for someone who, suffered a psychotic break after being prescribed these types of medications. So, and it wasn't a woman and it wasn't postpartum depression, but this, I just think makes it so much harder for the judge, for this young ass prosecutor. I mean, I want to slap her in the face already. It's like, can't anyone speak up and be like, yo, what are we doing here? What are we doing here? But I'm getting ahead of myself. So get us started, babe.
Yeah. All right. So I've optioned in this particular circumstance. We're not going to pull up the document. We're just going to read it, because when we're trying to clip for shorts, I don't want to have the document blocking us from being able to do that anymore. Occasionally we'll pull up documents, but you're just going to have to stare at Allison's beautiful face and, and
no
me.
bright light up here. I look disgusting.
Look gorgeous. Oh God, dude,
Where's my bright light?
No,
I need my bright light.
She says stuff like that, and I wonder if she's fishing. Are you fishing?
God, no. All right, just move on.
I mean, you're gorgeous. I don't know what the hell you're talking
sorry,
about.
you're right. I shouldn't have said anything.
Thank you. All right. Okay, so the first thing we're going to start off with is the affidavit to establish a probable cause that a murder, a violation of Massachusetts General Law, Chapter 265, Section 1, assault and battery with a dangerous weapon, and a strangulation, which subsequently they have dropped because it was redundant in terms of the charges. So this is the affidavit that was filed, and it's going to give us a pretty good idea of the background of the case if you're not familiar with it. So at approximately
from the state's perspective,
from the cop's perspective, from the state. So it's an affidavit for probable cause. So at 18:11 hours on Tuesday, January 24th, 2023, a person of interest being identified as Lindsay Clancy and the victims being identified as Cora, Dawson, and Callan. This affidavit does not contain all information known to investigators and is being used for the limited purposes for showing probable cause that evidence related to the crimes of murder, assault and battery, and with a dangerous weapon and strangulation with the victims, again identified as Cora, Dawson, and Callan, can be found at 47 Summer Street, Duxbury, Mass. I believe the following facts will establish probable cause for a court to issue a warrant authorizing the search of 47 Summer Street. All right, so I'm going to skip around. We're not going to read the whole thing because it's lengthy. So this is the investigation history. So on Tuesday, January 24th, 2023, at approximately 18:11 hours, Duxbury Police, am I pronouncing that right? Is it Dukes or Duxbury? Let me know, babe, if I'm saying it right, because I'm not looking at the chat. Dispatch radio called all cruisers to respond to 47 Summer Street in the town of Duxbury for an attempted suicide where the wife, who was positively identified as Lindsay Clancy, had cut her wrist and neck and jumped out of the window from the second floor. Police responded to 47 Summer Street and located Miss Clancy on the ground on the left side of the house. Located with Miss Clancy was her husband and the 911 caller, Patrick Clancy. So as police officers were assessing Miss Clancy, Mr. Clancy entered the home to check on his children. Police dispatched, then radioed to officers that the husband, Mr. Clancy, was in the basement and something was wrong because his children would not wake up. Officers then heard extremely loud yelling and entered the home responding to the basement. In the basement, police officers located Mr. Clancy and the family's three children, a 5-year-old, a 3-year-old, and an 8-month-old infant. The three children who were positively identified as Cora, Dawson, and Callan were all located in different areas of the basement on the floor, not breathing and unresponsive. All three children were transported by EMS to Beth Israel, Plymouth Hospital, where Cora and Dawson were both pronounced deceased. Miss Clancy was transported by EMS to South Shore Hospital in Weymouth. Callan was med-flighted to Children's Hospital in Boston. Police then secured the residence of 47 Summer Street. So also on Tuesday, January 24th of 2023 at 19:29 hours, Trooper Rabbit arrived at the emergency department of Beth Israel, and Trooper Rabbit met with police department official or officer Joseph Polini. Cora Clancy was located in exam room 3, and Dawson was located in trauma 1. Callan was located in trauma 2. However, he was med-flighted again to Boston Children's Hospital shortly after Trooper Rabbit's arrival. So on Tuesday, the 24th at 1948, Rabbit spoke with emergency department Dr. Mark Tenorwitz. Tenorwitz stated that he tended to Dawson Clancy upon his arrival at the emergency department, and upon arrival, Dawson Clancy was in cardiac arrest. Tenorwitz stated that he had been told that Dawson Clancy had an exercise band tied around his neck prior to being transported to BID Plymouth. Dr. Tenorwitz stated that Dawson Clancy had signs of strangulation, particularly on the side of his face. What is that medical phrase? Petechie, Petechie. I'm sure our nurses and doctors in the chat will let us know what the proper pronunciation of that is. So he had that on the side of his face. Tenorwitz stated that Dawson had a bruise on his right knee and an old bruise on his right shin. Tenorwitz declared Dawson dead at approximately 19:28 hours on the same date. On same date, at 2002 hours, Rabbit and Trooper Ashley Fiala of the Mass State Police Crime Services Scene Services Section observed Cora in Emergency Department Room 3. Cora was located on the hospital bed. She was covered in a white blanket and had medical devices protruding from her mouth and left ankle. Cora also had an AED, pads on her chest, defibrillator, and a neck collar around her neck. Cora also had gray and orange pajamas partially on her body, which had been partially cut off. Cora also had what appeared to be a bruise on the inside of her right bicep. Cora's hands were bagged by Fiala. Cora Clancy was digitally photographed by Fiala. Cora was later moved to BID Plymouth Morgue to be picked up by members of the Office of the Chief Medical Examiner for a postmortem examination. So same date, 2010 hours, Rabbit spoke with Dr. Benjamin Kaufman. Kaufman tended to Callan upon his arrival at BID Plymouth. Kaufman stated that he noted no specific injuries beside Callan being in cardiac arrest, as he was in critical condition prior to being med-flighted. So then at 2025 hours, Rabbit spoke with Dr. Michael Snyder. Snyder tended to Cora upon her arrival. He stated that Cora was in cardiac arrest upon arrival. Snyder stated that Cora had ecchymosis, bruising, popped blood vessels around her head, eyes, and neck. And Snyder stated that Cora had bruising to her chest, and he stated that most likely due to medical staff performing cardiopulmonary resuscitation on her. So at 2031, Lieutenant Lance Mello, Trooper Rabbit, and Trooper Fiala observed Dawson in Trauma 1. He too was located on a hospital bed. Dawson was located beneath a white blanket with a green hospital Johnny draped across his midsection. Dawson had medical devices on his chest, leg, AED pads on his chest, back, and tubes protruding from his mouth. Dawson's hands were bagged by Mello and Fiala. Dawson was digitally photographed by Fiala. Dawson was later moved to the BID Plymouth Morgue. to be picked up by members of the OCME for postmortem examination. So at 20:05 hours, I interviewed Duxbury police officer Brian Josephine at the police station. Josephine stated he works as a school resource officer during the day and was on an overtime shift from 1,600 to 2,000 hours, or 20. Well, how do they pronounce that again? I can never do it with military time. 2,000, 20, 2,000.
2120.
No, 20. It's just 2,000, 20.
2000.
2,000. That seems wrong.
I don't know, but a lot of people do want to read with us. If you get into a rant, I'll pull it down. I've been trying to do that.
You want me to put it up?
Yeah, just it's easier. It's easier for people who are there are a lot of people saying they're visual learners, but if you pause for a rant, I'm gonna pull it down. I've been trying to do that.
I'm not going to be ranting during the affidavit anyway. So all right.
And we're gonna need it up for the complaint because that people are gonna need to see to follow.
Yeah. Okay, I'll pull it up.
You've been heard, people. Your voices have been heard.
You've been heard. I mean, they don't care that we're trying to, like, maybe if you guys helped us get over 70K, I wouldn't be so worried about making, it's like we're 300 away.
I bet all 700 people here are subscribed already. But if you're not, go do it. It's free.
I'm like done being nice about it. It's guilt time. Guilt time. All right, let's see.
How are you going to guilt the new people?
Huh?
All the existing people have subscribed. The new people just be like, this guy's weird.
I don't know that they're all like, people watch channels all the time that aren't subscribed to them. That's not true. You're inaccurate with that, my love.
Well, they can't be chatting, so.
Well, yeah, I guess that's true. I should make it for days. You can't chat unless you're subscribed for days. It's free.
People will move on.
So
They'll be like, I
free.
can't chat for days. I'm out.
That sounds like a them problem.
All
I mean,
right.
go watch some other shit. I think we're the best out there. So, but that's just me.
2,000 hours.
2,000. Thank you.
It's the time 2000.
Okay. All right. Right.
I don't know why I said that.
I don't know either.
Gosh.
Right.
I'll just blame perimenopause brain.
This is no laughing matter.
But that's what some people think of when they hear, postpartum depression. Oh, that's just somebody like, I'll blame postpartum depression. And that's what needs to get changed.
Well, I don't ever want to hear a man, like I was talking to you offline about it. Like I have no interest in hearing any man ever talk about postpartum depression ever at any point. They have no frame of reference. They have no experience with it. They have no business talking about it ever. They couldn't possibly know what it is. They couldn't possibly know what it feels like. So shut the fuck up.
To tell you the truth,
leave it to the women.
There's several women who have an experience that, I mean, I couldn't tell you. I can appreciate that women suffer it, but thank God, luckily, I've never had to experience it. So I really, it's almost as bad as a man, but all right, we're getting back to the
you menstruate, like you do things that I could never explain or understand. I mean, like you can speak on it.
Sometimes.
I can't.
Not often anymore.
Let's leave it at that.
Oh,
let me handle the button push.
Okay. But I'm going to remove it when you start to rant, and then I'll let you put it back up. Okay. Deal.
Okay. So Officer Josephine, plus you can help me read. So Officer Josephine stated as he was going to the left side of the home, Mr. Clancy was on the left side of the home and walked past him and entered the home. Josephine stated that he was assessing Mrs. Clancy. Oops. Am I pronouncing Duxbury right? Is that right?
They said ducks.
Okay, good. Okay, so Duxbury Police Dispatch radioed something about the home's basement before he heard the extremely loud screaming. I wish I would have gone through and highlighted this because shit's redundant. Okay. Okay. So this is where we start getting into some of the facts. Okay, so Josephine stated he entered the home through the rear sliding door, which was already open. Officer Josephine stated that he entered into the kitchen and then took a left to get to the staircase to the basement. Josephine stated that Mr. Clancy was still screaming. Officer Josephine stated that he went down to the basement stairs and turned right. Josephine stated that the basement was divided into a left side and a right side. Josephine stated that Mr. Clancy came out from the far room and stated, quote, "She killed the kids." So Josephine stated that he entered the rear room and believed he observed the 2-year-old laying on his back unresponsive and was blue and purple in the face. Josephine stated that he believed he saw bruising on the child's neck. Josephine stated that there was a blue resistance band next to the child's head. Josephine stated that he grabbed the child and ran him up the stairs and out the front door and into an arriving ambulance. Josephine stated that he then returned to the basement and turned left this time. He stated that he observed the family's 2 other children on the ground unresponsive, both having life-saving measures performed by Duxbury EMS. Officer Josephine stated that the rooms to the right in the basement appeared to be a weight room style room and an office. And the area to the left in the basement appeared to be a living room area with couches. Josephine was unsure of the layout of the basement because he was focused on the children. So at 2023 hours, I interviewed police officer Stephen Hull at the Duxbury police station. Hall stated that he was working his scheduled shift from 1600 to 0000 hours. Officer Hall stated that he received a radio transmission from Duxbury Police stating that all cruisers responded to 47 Summer Street for a female that possibly attempted to unalive herself and had lacerations to her wrist and neck and also jumped from a second floor window. So Hall stated that he arrived at 47 Summer Street at the same time as Josephine. Hall stated that when he was approaching the house, he heard someone say, "Over here, over here." Hall stated that he ran to the left side of the house and saw Mr. Clancy standing by Miss Clancy, who was laying on the ground. Hall stated Miss Clancy was laying on her back with her head towards the house and had lacerations on her wrist and neck. Hall stated the lacerations were not currently bleeding. Hall stated that Miss Clancy was breathing but was semi-conscious. Hall stated that Mr. Clancy then ran into the house, and then he heard Duxbury dispatch radio something about Mr. Clancy saying there was something wrong in the basement and they won't wake up.
All right, I think
Officer
you can
Hall.
jump to when they start, like, because they kind of, like you said, repeat it. Go to 17, maybe.
Wait, I don't want to miss the things where it's
Okay,
like
you're
things
right.
that were stated.
I'm sorry.
So Hall stated that he entered the home through the rear door and entered the kitchen. Hall stated that he took his second left and proceeded down the basement stairs. Hall stated that he turned right and he saw the husband coming out of the room stating, "Oh my God, and was breathing heavily. Hall stated they went into the back room and located what he believed was the oldest child. He then ran up with the child and put her in a waiting ambulance. He stated in the basement left was the couches. Okay, so he observes all the children were blue in the face. He stated the first child on the right of the basement had no shirt on, their face and chest were blue. He stated when he exited the house the last time, he observed the window on the second floor on the rear left of the home. The window frame had blood on it when looking from the ground. God, just an unbelievable nightmarish scene.
I'll take over because I'll start here. Officer Cahill stated he went down the basement. Oh, wait, sorry. Officer Cahill stated when he arrived on scene, the Duxbury police officer and EMS were on the scene. He stated that he opened the front door of the home for EMS to access the front of the home. Officer Cahill stated he then went downstairs to the basement and observed Mr. Clancy pacing back and forth. I feel like we can maybe skip this, like the stuff again.
Man, if you're gonna start skipping shit,
no, but like where the kids are laying and they're and how they look.
I agree with that, but like
because I can't
want to
take
get the
it.
bulk of it.
Right, but now they're going to talk about it right now.
Yeah.
I mean, the kids were in horrible condition, so let's go past that.
Okay.
Thanks. We'll look for anything where she says anything. So here we go. This part's important. Officer Cahill stated that he had observed indents of trauma. No. Okay. Officer Cahill stated he was able to talk to Mr. Clancy, who stated he had gone out to pick up food and make another stop before returning home. Officer Cahill stated Mr. Clancy returned home and realized the home was quiet prior to locating Mrs. Clancy.
The other stop was CVS to pick up a script.
So they go on about, they're in the hospital. And then there's a summary of an interview. So that is, I think you can read 20 safely now.
Okay. Patrick Clancy stated They had been married to his wife, Lindsay Clancy, for 6 years, and then they have 3 children together. Patrick Clancy stated that at the end of September of 2022, Lindsay Clancy stated that she was beginning to get anxious prior to her return to work at Mass Gen Hospital as a labor and delivery nurse. Patrick stated that Lindsay went to a psychiatrist who he later identified as Jennifer Tufts and was prescribed Zoloft. Patrick stated that Lindsay also saw another psychiatrist who he identified as Rebecca Gelada. Patrick stated that Lindsay was also prescribed multiple other medications, including Valium, Trazodone, Ativan, Klonopin, Prozac, and Seroquel. Patrick stated that Lindsay would take as many as 4 medications a day. However, she would take them as prescribed. Patrick stated that Lindsay called the restaurant 3V in Plymouth at approximately 17:15 hours and the same date for takeout food. And Patrick Clancy went to pick up the food. Clancy stated that he also stopped at the CVS in Kingston near the Duxbury line and purchased laxative for his daughter, Cora. Also, it was laxative, not a script. Patrick stated that he arrived back home at his residence and noticed that the whole house was quiet.
I just wanted to chime in because it could have been a child specifically prescribed laxative too.
Yeah. Patrick stated that he went upstairs to his bedroom and his bedroom door was locked. Patrick stated that after he got into his bedroom, he saw blood on the window, or blood in the window was open. So he then ran downstairs and outside and located Lindsay on the ground. Patrick stated that when he located Lindsay on the ground outside, it appeared she had slit her wrists and possibly her neck. Patrick stated that he then called 911. Patrick stated that the police then arrived at the house, and he stated that he went to the basement where he located the kids in the main living room and Dawson in his office. Patrick stated that all 3 children had workout bands tied around their necks. Clancy stated that he was home all day, with the exception of when he left the residence to go to 3V and CVS. Patrick stated that Lindsay stated that she had been having suicidal thoughts as well as thoughts of hurting the children. He clarified that she had communicated that she was feeling that way at the end of December. Patrick stated that Lindsay had reached out to her psychiatrist, Jennifer Tufts. Patrick also stated that Lindsay had self-admitted her to McLean Hospital from January 1st of 2023 through January 5th of 2023. Patrick stated that he and Lindsay had, quote, an amazing marriage and, quote, got along great. He further stated that they tell each other they love each other at least 10 times a day. And at the end of the interview, Mr. Clancy consented to have his face, clothing, and hands digitally photographed by Trooper Fiala.
I think we can skip this. They talked about the time for the travel.
Really?
Yeah.
This is like, this is
I mean,
their
you could
evidence.
give the. All right, I was going to say
This is their primary
time.
evidence. This is
All right.
this is what they're nailing her on in their estimation, because she did the planning.
Okay.
He was able to review Apple Maps and calculate the travel times for Mr. Clancy's travel. Chio stated it takes approximately 3 minutes to travel from 47 Summer to CVS. He stated it takes approximately 8 minutes to travel from CVS to 3V. So Chio stated that it takes approximately 9 minutes to travel from 3V to 47 Summer Street. So let's see. So on the 24th at 21:09 hours, Chio visited the 3V located at 10 Cordage Park. During the course of the investigation, investigators learned that Patrick entered 3V to pick up the food after leaving his house on the evening of January 24th of 2023.
29.
Yeah, sorry. 20, wait, what?
Just go to
2023.
29.
Oh.
No, I was right.
Okay. Why?
Because
Like, this is
28
the kids I
provided
told
us access to the video, so now 29 says.
All right. The video shows Patrick enter 3 feet through the front door at 17:54 and 14 seconds. Patrick glances at the takeout table, then waits in line behind a couple for a brief moment. While waiting, he looks at his cellular telephone. After the couple leaves, he approaches the hostess desk to pick up his order. He pays for his order at 17:55:01. Mr. Viscariello, sounds like a nice Italian guy, informed us the hostess was Saria Sweeney. Patrick paid with an American Express card. Viscariello printed a copy of the receipt for us, and the receipt showed the order for the 2 items was placed at 17:10.
So there's an important fact. So Lindsay places the order at 17:10, right? And he picks it up about 45 minutes later.
Yeah. What time did he get there? Yeah, 17:55. Okay. So, all right. So, okay, they go to CVS. So, Ferrioli and Chiachio go to CVS on the same day, 21:40 hours. And they learned that Patrick entered the CVS after leaving his house on the same date. And they spoke to the manager. She provided access to the surveillance. Video shows that Patrick entered the CVS through the front door at 17:32:32 and walked to aisle 20. Miss Krause informed us aisle 20 is where they keep children's medication.
So you're right. It wasn't a script. It was over the counter.
Patrick spends only a few minutes in the children's aisle before exiting the aisle and walking back towards the registers. As he does this, just prior to exiting the camera frame, Patrick appears to be utilizing his cellular phone. Patrick arrives at the register at 17:36:12, no longer utilizing his phone. Patrick exits the store through the front door at 17:37:08 and turns right. Ms. Krause informed us that there were no exterior cameras showing the side of the building. They downloaded it onto a USB and handed it over. They stuck it into evidence. So the conclusion, he's got personal knowledge based on his training and experience and the collective knowledge of the other investigators that oftentimes individuals involved in the commission of crimes of violence are in contact with their physical surroundings and oftentimes carry evidence or trace evidence from the scene to their place of residence that, if collected, will assist in the identification of perps or the nature of the crime. Also, in crimes of violence, there's often an attempt to alter, destroy, clean up, or remove evidence from the crime scene, of the crime from the scene. However, in each case, traces of evidence may be carried from the scene in many forms, including blood, skin, semen, saliva, hair, fibers, fingerprints, palm prints, and shoe prints. He's also, from his personal knowledge, training, experience, that evidence to assist in the identification of a perpetrator may also be carried from the scene and kept in their place or residence of a trusted person's place or residence. This evidence may be detected in the above mentioned trace evidence, as well as in the form of written or electronic records, writings, electronic messages, storage devices, including hard drives, zip drives, thumb drives, and CDs, computers, cell phones, video and audio tapes, audio, video surveillance systems, photographs, footwear, credit cards, and records, bank records, telephone and cellular telephone records, cutting instruments, sharp objects, prescription medication, and exercise and resistance bands. Okay. Okay. I have knowledge that it is common for perpetrators of violent crimes to not only possess trace evidence on their clothing, but to keep the clothing and footwear they wore at the time of the act. Furthermore, even if the clothing and footwear were washed, they could still contain microscopic trace evidence. Also, certain characteristics such as footwear impressions and clothing would still exist and be useful evidence. In my experience, the above evidence could be found at the scene. All right, so this is where he just lists everything that he's looking to get in the warrant. So computers, laptops, iPads, tablets, cell phones, and other such electronic devices to research certain aspects of their crimes, such as victim residences, routes of travel, means of concealing their crimes, etc.
So that's all their evidence of pre-planning that they're looking for.
Right.
Yep.
All right. So this is redundant. Okay. Based on the foregoing and reliable information upon my personal knowledge and belief, I believe that further items of evidentiary value relative to the investigation of the murders of Cora Dawson and Callan, and the crimes of strangulation and assault and battery with a dangerous weapon may be found at 47 Summer Street, inside the residence, as well as the curtilage. Okay. The evidence for which I seek for the search warrant is as follows: clothing traces of evidence, which may be in the form of blood, saliva, scanned hair, fibers, fingerprints, palm prints, shoe prints, written or electronic records and or notes, handwritten notes, writings, electronic messages, storage devices, including zips, thumb drives, DVDs and CDs, cellular telephones, and specifically Lindsay Clancy's phone, video and or audio tapes, audio or video security surveillance systems, photographs, computers, laptops, iPads, electronic tablets, and other such electronic devices, footwear and cellular telephone records, cutting instruments, sharp objects, prescription medication, exercise and resistance bands, and any other type of ligature which may be found at the residence located at 47 Summer Street, Duxbury. Okay, so he describes the property, a two-story single-family home with a basement. The home has blue wood shingle and vinyl siding with white trim and a white front door. The home has a garage and a driveway to the right of the home. In the driveway is a 2020 white Chevy Silverado and a 2019 Kia Sorento. All right, so that's that. So then this is 200 plus pages. That's all we're going to go through in terms of the affidavit. You have multiple cops that drafted up affidavits. And as they were talking about with the collective knowledge doctrine, they're basically, that one cop basically said what all the other cops are saying in their particular affidavits as well.
Oh, but I did want you to go back to the one paragraph where
Which
they
one?
talk about that she talked, what she said to the one where her husband says he also checked him in, because he says that she, I think it's around 26.
26 of the first one. Okay.
Yeah.
Sorry. Close your eyes. Okay.
Nope. Keep going.
Up.
Yeah. Where he says that how she's been feeling. Oh, here, there it is. 25.
Yep.
So I just want to note, Patrick Clancy stated that Lindsay Clancy stated she had been having unaliving thoughts as well as thoughts of hurting her children. So, I mean, that's what has been fleshed out here. But when we get to the civil complaint, you can expect for that to be obviously much more detailed, to not only be focusing on the facts that the state wants to put forward. And that's why for our primer, we choose to cover that, because it's going to give you so much more information. But before we do that, what was our next step that you were?
All right. So the next thing we're going to do is we're going to look at the jury instruction.
So now this is the jury instruction dealing with the defense that they're employing here.
Yep.
Because it's not called insanity, but it's going to give you the elements of what they need, the burden that's on the defense, when the burden shifts, I'm assuming.
Yep. Because ultimately it's the state's burden on both.
Right. To disprove it beyond a reasonable doubt once the
prima facie case is established by the defense. All right, let me see. Let me see if this
While you're doing that, I just want to go over the first four. They're not actually questions. So we've got Massachusetts C. Glass became a member. What does Massachusetts C. Glass get, babe?
Oh, family hug.
And Jade Zia Dax, member for 16 months. Thanks for your continued support.
Thank you.
Says happy to catch a live. Love and hugs to all the DD family. I think everybody needs it right now.
Everybody needs hugs today.
Yeah, this is so hard. Everything. Dog Grooming Danny gifted 20 Defense Diary podcast memberships. Very, very generous, as is MBW007, who gifted 5 memberships. Thank you all. And then Amanda, member for 19 months. Thanks for your continued support. Glad last night fell through. Wanted to be here. And she's speaking of, we had this set for last night. We were having some internet instability, so we switched it to today. So thank you for that.
Yep. And make sure to like, share, and subscribe. It's all free. Don't forget. All right. So this is what they call a pattern jury instruction in Massachusetts. And this particular instruction is 9.200, lack of criminal responsibility. And we'll split this because it's a pretty lengthy instruction, babe. All right. So if the Commonwealth has proved the elements of the offense beyond a reasonable doubt, okay, so that is the red rums, okay,
which are not at issue here. So
they're not at issue.
This is literally the only issue in the case because obviously both sides agree what mom did, that she did it, and they're
still going to put on the evidence, though.
They're still going to put on the evidence.
They're going to still put on the evidence. So if the Commonwealth has proved the elements of the offense beyond a reasonable doubt, the Commonwealth must also prove beyond a reasonable doubt that the defendant was criminally responsible at the time of the alleged offense. Under the law, a person is not guilty if they lacked criminal responsibility when they committed the offense. This is sometimes referred to as not guilty by reason of insanity. There is no burden on the defendant to prove that they lacked criminal responsibility. The Commonwealth may meet its burden of proving a defendant was criminally responsible for their conduct in either of two ways. The first way is for the Commonwealth to prove beyond a reasonable doubt that the defendant did not suffer from a mental disease or defect at the time of the alleged offense.
So that's going to never happen. I think both sides agree that she did. It's going to be the second aspect. Wait, does it say or? Oh, right.
Yeah,
or, right.
Mental disease.
He doesn't have a mental disease or defect. That's the first, right? So got it.
Right. So a mental disease or defect need not fit into a formal medical diagnosis. It is a legal term, not a medical term. It does not, however, include an abnormality that presents itself only by repeated criminal or otherwise antisocial behavior. It is for you to determine, and remember, this is a jury instruction. It is for you to determine from the evidence whether the defendant had a mental disease or defect at the time of the alleged offense. Okay. Do you want to read this case law that they have included in there, or skip it?
I was just looking at it to see if it seemed like, I don't think so.
Okay. All right. So the second way for the Commonwealth to prove the defendant was criminally responsible for their conduct is for the Commonwealth to prove beyond a reasonable doubt that even if the defendant suffered from a mental disease or defect at the time of the alleged offense, the defendant nonetheless retained the substantial capacity to appreciate the wrongfulness or criminality of their conduct and to conform their conduct to the requirements of the law.
So, and if that was here in Illinois, that end wouldn't be there. That's it. You know, the difference between right and wrong. That's what they mean when they say appreciate the wrongfulness of their criminality. So this end is pretty big here.
It's pretty big. So it's to establish that the defendant had the substantial capacity to appreciate the wrongfulness or criminality of their conduct, the Commonwealth must prove beyond a reasonable doubt that the defendant appreciated, that is, that the defendant knew or understood in some way that their conduct was either illegal or wrong. To establish that, the defendant has the substantial capacity to conform their conduct to the law's requirements. The Commonwealth must prove beyond a reasonable doubt that any mental disease or defect that may have existed at the time of the alleged offense did not deprive the defendant of their ability to behave as the law requires, that is, to obey the law.
Now, this one we do. Let's read that little bracketed. If there is evidence that a defendant had a mental disease or defect and consumed drugs or alcohol, continue with supplement 1. If not, can continue here. Now, because that would be a difference. Once somebody's like, all right, you knew you had a mental disease or defect, and then you consumed some sort of illegal drug or alcohol, that's going to bring in a different factor. That is not at play here. But I just want to point that out because you also have, I heard her lawyer mentioned involuntary intoxication, meaning she's taking medicine as prescribed, but it is intoxicating her in a way that she did not anticipate, she was not aware of, and was completely involuntary, which is kind of, it's a different sort of spin on the law, because typically it's like, did you drink it or didn't you? Now, obviously, if you drank apple juice and someone spiked it with something, that would be different. But if under the law, most of the times, if you intentionally consume alcohol or some other substance, then that's intentional intoxication and there is no defense. So we might, be seeing some nuances with that as well, not to get us too sidetracked. I'm sorry.
All right. So to summarize, if the Commonwealth proved beyond a reasonable doubt that the defendant did not have a mental disease or defect at the time of the alleged offense, the Commonwealth has satisfied its burden of proving that the defendant was criminally responsible. Alternatively, if the Commonwealth proved beyond a reasonable doubt that even if the defendant did suffer from a mental disease or defect at the time of the alleged offense, the defendant nonetheless retained the substantial capacity to appreciate the wrongfulness or criminality of their conduct and to conform their conduct to the requirements of the law, the Commonwealth has satisfied its burden of proving the defendant was criminally responsible. Remember that there is no burden on the defendant to prove that they lacked criminal responsibility at the time of the offense. Rather, the burden is on the Commonwealth to prove beyond a reasonable doubt both that the defendant committed the offense and that the defendant was criminally responsible at the time that they committed the offense. If you have a reasonable doubt whether the defendant committed any one of the required elements of the alleged offense, you must find the defendant not guilty. If you have a reasonable doubt whether the defendant was criminally responsible at the time of the offense, you must find the defendant not guilty by reason of a lack of criminal responsibility.
And then I do think the couple of these are important. If you blow them up, I'll read them.
Yeah, like McCool is like the main case that they use.
Right. So they're saying that they adopt that definition of insanity from the model penal code, but a defense of lack of criminal responsibility may be raised by, quote, any evidence which, if believed, might create a reasonable doubt concerning the defendant's criminal responsibility at the time of the crime. So that's where they're just saying, like, if there's no lack of criminal responsibility, even like referenced by the defense or by the evidence, then then the state doesn't have to go separately proving this, but it can be raised by anything. Expert testimony is not always required to raise such a doubt. The defendant may rely on the facts of the case, the Commonwealth's witnesses, the testimony of lay witnesses, or any combination. It goes on to quote other cases that stand for the proposition that defendants' psychiatric records, observations by lay witnesses, nature of the crime, all of that counts. This court's view has consistently been that, quote, where the appropriateness of an insanity instruction is marginal, the better choice would seem to err on the side of giving it. So once the issue of insanity has been raised, the Commonwealth must prove beyond a reasonable doubt that the defendant was sane at the time of the crime. The Commonwealth must prove both the defendant's substantial capacity to appreciate the wrongfulness, and again, that's just knowing the difference between right and wrong, and his substantial capacity to conform his conduct to the requirements of law. The judge may not limit an instruction on lack of criminal responsibility to the specific medical diagnosis raised by the defense psychiatric expert, since the burden of proving sanity remains on the Commonwealth and the jury is not bound by any particular definition of mental disease or defect. So I don't think that we have this supplement needs to be because she didn't take any drugs or alcohol.
Yeah, when we're saying drugs, it's obviously not including prescription medication. Okay. Let's see. I don't think that one is going to apply as well.
And it's if that changes, and it's possible that we'll raise that one. But basically, we could go to this summarize. To summarize, in order for the Commonwealth to meet its burden of proving the defendant was criminally responsible at the time of the alleged offense was committed, that is, the defendant did not lack criminal responsibility at the time, the Commonwealth must prove at least one of the three or four facts beyond a reasonable doubt. One, that the defendant did not suffer a mental disease or defect at the time of the offense. Two, that even if the defendant did suffer from a mental disease or defect at the time of the offense, the defendant nonetheless retained the substantial capacity to both appreciate the wrongfulness of their conduct and to conform their conduct to the requirements of the law. Or three, that if the defendant lacks substantial capacity to appreciate the wrongfulness of their conduct or to confirm their conduct to legal requirements, the defendant's lack of such capacity was solely the result of voluntary intoxication or by alcohol or other drugs. So again, and then they have where there is evidence that the defendant's knowledge of that consumption, drugs or alcohol, would trigger the intensity of a mental disease or defect. So that's when this 4 would come in, which doesn't come into play. Again, that would be like he knew he had an illness that taking alcohol or drugs would like spur out of him and took it anyway. So
all right, and then they just get into when the jurors must find her if they don't meet both of those burdens in terms of obviously the crimes in and of themselves are, as Allison said, those are a foregone conclusion. This case is going to rest entirely in the second thing that they have to prove beyond a reasonable doubt. All right, so at this point, I think it'll be well, this is interesting. Pop it back up.
okay.
So this is what can happen. So
It's
this
the
is the consequences. Okay. So your decision must be based solely on the evidence in the law of this case, without regard to the possible consequences of your verdict. You may not consider sentence or punishment in reaching your verdict. You are, however, entitled to know what happens to a defendant if found not guilty by reason of a lack of criminal responsibility. A judge may order the defendant to be hospitalized at a mental health facility for a period of observation and examination. During that period, or within 60 days of the verdict, the district attorney or other appropriate authorities may petition the court to commit the defendant to a mental health facility or to Bridgewater State Hospital, initially for a period of 6 months. At the end of 6 months and every year thereafter, the court reviews the order of commitment. If the defendant is still suffering from a mental disease or defect and is still dangerous, then the court will order the defendant to continue to be committed to the mental facility or to Bridgewater State Hospital. There is no limit to the number of such renewed orders of commitments as long as the defendant continues to be mentally ill and dangerous. If these conditions do continue, the defendant may remain committed for the duration of his or her life. If at some point the court determines the defendant is no longer mentally ill and dangerous, the defendant will be discharged. The district attorney may be notified of any hearing, and the district attorney may be heard at any such hearing. However, the final decision on whether to recommit or release the defendant is always made by the court. All right, so that's an important thing to note. All right, so let's go to.
While you're pulling that up, I just want to say welcome to Shauna Parker. Thank you. Welcome. Family hug.
Yeah.
So what we're going to pull up now is Rosemary Scapiccio's civil complaint in this case.
Exactly.
On behalf of Lindsay.
And the reason that we want to do that is because it really goes to the heart of what the defense is, and it breaks it down.
And it tells you all the way more of the background than what we just got.
Yes. And we're going to skip, obviously, some of the stuff like jurisdiction. We'll go through briefly the parties. So it's Lindsay Clancy v. Jennifer Tufts, MD, Aaliyah Goodhart, MD, Diaz, MD, Gelada, CMP, Astor Mental Health, Inc., South Shore Health System, Inc., McLean Hospital, and Women and Infants Hospital of Rhode Island. They are all defendants in the case. And again, Rosemary is handling this. She's handling the civil side of it. This is an action for personal injury and loss of consortium brought by Lindsay Clancy.
That would be her losing the affection and love and life of her children.
Yeah. And potentially her husband, but her husband is standing by her. So this action arises from the catastrophic failure of multiple medical providers to properly diagnose, treat, and monitor Lindsay's severe postpartum psychiatric condition, despite her repeated desperate pleas for help and her family's persistent efforts to obtain adequate care. Lindsay Clancy did everything a mother in her situation could do. She recognized that something was wrong with her. She sought medical treatment. She went to emergency rooms. She called crisis hotlines. She admitted herself to hospitals. She took the medications prescribed to her. She communicated her worsening symptoms to her providers. She told them the medications were making her worse. Her husband advocated for her. Her family drove out from out of state to help her care for the children. And still, the medical system failed her completely. The defendants, as I stated prior, each failed to properly diagnose Lindsay's bipolar disorder with postpartum onset, and instead subjected her to a disorganized, uncoordinated course of polypharmacy that exacerbated her condition and precipitated a severe psychotic break. Lindsay's clinical course was, quote, significantly complicated by polypharmacy and involvement of multiple prescribers, which in effect obscured an accurate diagnosis and appropriate intervention and treatment, even though Lindsay did all that she could to obtain the appropriate treatment. The psychotropic medications Lindsay received appeared to have paradoxically exacerbated her underlying psychiatric vulnerability, precipitating a state of manic psychosis characterized by compelling command hallucinations. The tragedy that followed was the direct and proximate result of the defendant's collective negligence in failing to recognize obvious warning signs, coordinate care, properly diagnose Lindsay's condition, and provide treatment that met. Sorry, I got lost. There was a floating.
The applicable standard of care.
Yeah, I thought it was a mosquito, and provide treatment that met the applicable standard of care. As a direct result of the defendant's negligence, Lindsay suffered catastrophic physical injuries, including permanent paralysis, and she lost her three beloved children, Cora Marie Clancy, Dawson William Clancy, and Callan Patrick Clancy. Lindsay now faces a lifetime of physical disability, psychological trauma, and the unbearable grief of waking up every day knowing that she killed her children, all of which could have been prevented had the defendants provided competent medical care. Some kind of floater, babe. All right, so the parties. So it talks about, obviously, Lindsay. She's a resident of Mass. And that she resides with her husband and formerly with her three children. She was a registered nurse who worked in the lab or labor and delivery department at Mass Gen. So Tufts is
I'm just going to take a little break there. You know, there's lots of different ways that you can be a nurse. Someone who chooses labor and delivery, that's someone who wants to work around children, loves children, cares about children. I mean, those nurses are the most amazing people that, you know, a woman giving birth, like, makes or breaks the whole delivery, the whole stay. You know, just the mere fact that that is the field that she has chosen to go into says something to her about a woman and caring for babies.
All right. Okay, so Tufts is a MD, a psychiatrist registered to practice medicine in the Commonwealth of Mass. Goodhart is a psychiatrist registered to practice medicine in the Commonwealth of Mass, and she usually works at McLean Hospital. Goodhart was the attending psychiatrist who authored and signed Lindsay's physician discharge summary on January 5th, 2023, following Lindsay's 5-day inpatient admission. Zobeda Diaz, MD, is a psychiatrist registered to practice medicine in the state of Rhode Island, and she works, her normal place of business is the Women and Infants Hospital in Providence, Rhode Island. She was the attending physician who evaluated Lindsay at the Women and Infants Day Hospital program on December 20th of 2022. Defendant Jolada CNP is a certified nurse practitioner, and she is also licensed to practice in the Commonwealth of Mass with a usual place of business in Weymouth County. Defendant Astor Mental Health is a Mass professional corporation with a principal place of business in Braintree, Norfolk County. Astor also employed Dr. Tufts and is vicariously liable for her negligent acts and omissions. Defendant South Shore Health Systems is a Mass nonprofit corporation with a principal place of business in Weymouth, Norfolk County. And they employed Nurse Jolada and operated the perinatal behavioral health program through which Lindsay received treatment. South Shore is vicariously liable for the negligent acts and omissions of its employee. Defendant McLean Hospital is a psychiatric hospital located in Belmont, Middlesex County. McLean provided inpatient psychiatric treatment to Lindsay from January 1 through 5, 2023. McLean employed Dr. Goodhart and is vicariously liable for her negligent acts and omissions. And then Defendant Woman and Infants Hospital of Rhode Island is a hospital located in Providence, and they operated a partial hospitalization day program for patients with postpartum depression, where Lindsay sought treatment in late December 2022. So Women's and Infants employed Dr. Diaz and is vicariously liable for her negligent acts and omissions. Jurisdiction is proper because the injuries took place in Massachusetts, so obviously the suit is in Massachusetts. And this just establishes that they have jurisdiction over all the defendants. All right, so let's get to the facts here. Okay, so Lindsay Marie Clancy, born August 11th of 1990, was raised in Wallingford, Connecticut. Her formative years were characterized by consistent academic excellence, culminating in a distinguished record throughout college and a rigorous accelerated nursing program at Mass Gen Hospital. Lindsay's 9-year tenure as a labor and delivery nurse at Mass Gen demonstrated notable professional competence and personal fulfillment. She was passionate about nursing and dedicated to her patients. Lindsay married Patrick Clancy in December of 2016, and they established their family home in Duxbury, Mass. Lindsay and Patrick had 3 children, Cora, Dawson, and Callan. As described by Patrick Clancy, before Lindsay became ill, she was dedicated to being a mom, even over-dedicated, worked twice as hard as most. She rarely took a break to rest. Lindsay, quote, loved our children and, quote, never took her frustrations out on the kids. She remained as affectionate with the kids as always. Lindsay's mother-in-law, Susan Clancy, testified in grand jury proceedings that she, quote, loved everything about Lindsay. She was a fun-loving, doting wife and mother. She loved her kids, and she was a nurturing mother who smiled all the time. Lindsay's sister, Allison Olga, described Lindsay as, quote, the kind of person who cares deeply for the people she loves. She shows up for the celebrations and writes handwritten notes to show her love and appreciation. She's also there in times of need and finds just the right words to provide comfort and support. Lindsay consistently conveyed profound affection for her children and husband. She had never previously engaged in any form of physical harm towards her children. B, Lindsay's postpartum history. During Lindsay's first pregnancy with Cora, she experienced anxiety due to an abnormal ultrasound finding that later resolved. She experienced some anxiety during the postpartum period, but returned to part-time work and breastfed for 1 year without incident. During the postpartum period following her second child, Dawson, Lindsay was initially elated with the increased energy. Patrick described that, quote, she had manic behavior for multiple days. In October of 2020, she had an episode of decluttering to, quote, simplify her life, obsessively cleaning and discarding items. She said she felt, quote, amazingly on top of things, end quote. Her thoughts raced and she constantly felt pressure to be active. After her second pregnancy, anxiety emerged at approximately 2 months postpartum. Although Lindsay was offered Zoloft by a psychiatrist, she declined due to concerns about breastfeeding. Her symptoms resolved through exercise, healthy diet, meditation, and several therapy sessions. These prior postpartum episodes, including the hypomanic symptoms following Dawson's birth, were critical indicators that should have alerted competent psychiatric providers to the risk of bipolar disorder and the potential for more severe postpartum psychiatric complications following subsequent pregnancies. The third pregnancy and initial postpartum period. Lindsay gave birth to Callan on May 26th of 2022. Both Callan and Lindsay took parental leave following Callan's birth. Lindsay demonstrated significant activation and hypomanic behavior, including an extensive program of exercise beginning only 1 week after delivery. She woke every day before the children at 4 a.m., ran 3 miles, did spinning for 30 minutes on the Peloton, and then 30 minutes of aerobics. On July 4th of 2022, only 5 weeks after delivery, she ran a 5-mile race. Lindsay's sister Allison observed that unlike her usual sensible self, Lindsay impulsively bought into a Beachbody multi-level marketing scheme, purchasing products to resell. She made videos of her exercise routines, posted them on Facebook, and encouraged friends to join the program. These early postpartum behaviors constituted a hypomanic episode that, combined with her history following Dawson's birth, should have immediately suggested bipolar disorder to any competent psychiatric provider who obtained an adequate history. Lindsay's desperate efforts to seek help. Sorry, put this thing on mute. At approximately 12 weeks postpartum, Lindsay's mood switched suddenly to anxiety and depression. She experienced debilitating anxiety, insomnia, sleeping only approximately 3 hours per night, and exhaustion during the day. She had no motivation and could not exercise. Everything about her body felt heavy and required effort. It was a chore to dress or shower. Her parents came from out of state to help care for the children. Recognized that something was seriously wrong, Lindsay took the initiative to seek psychiatric care. On September 12th of 2022, she found Dr. Jennifer Tufts online and scheduled an appointment. At her first appointment with Dr. Tufts, Lindsay's Edinburgh Postnatal Depression Scale (EPDS) score was 23, indicating severe depression. Dr. Tufts prescribed Zoloft despite Lindsay's hesitation about medication due to breastfeeding concerns. Lindsay awaited approximately 2 weeks before taking the medication, still concerned about its effects on breastfeeding, but ultimately began taking Zoloft in mid-October 2022 because she knew she needed help. After increasing the Zoloft dose from 25 milligrams to 50 milligrams as prescribed, Lindsay experienced a severe adverse reaction. She did not sleep for 48 hours, had racing thoughts, worsening anxiety, and felt awful. This dramatic departure from her previous sleep patterns was an obvious warning sign of medication-induced activation consistent with bipolar disorder. Lindsay promptly reported these symptoms to Dr. Tufts on October 20th of 2022. Rather than recognize the significance of this reaction and conducting appropriate testing to determine why Lindsay had such an adverse response to a relatively low dose of medication, Dr. Tufts simply discontinued the Zoloft and prescribed Ativan and Benadryl for sleep. Even after carefully tapering these medications, Lindsay's profound insomnia persisted, accompanied by distressing cardiac palpitations. Her condition continued to deteriorate. On November 16th of 2022, Lindsay's insomnia had become so severe that she took herself to the emergency room at South Shore Hospital seeking help. She reported insomnia, anxiety, and palpitations. The ER doctor prescribed trazodone for sleep, but it was not effective. Patrick's mother, a nurse at South Shore Hospital, contacted the South Shore Prenatal Behavioral Health Program on November 20th of 2022, seeking additional help for Lindsay. Nurse practitioner Julie Paul reached out to Lindsay. Lindsay reported to Nurse Paul that she was, quote, very frustrated and scared, experiencing extreme insomnia, averaging only 3 hours per night and having racing thoughts. Nurse Paul prescribed Prozac on November 21st of 2022. After merely 4 days on Prozac, Lindsay reported that the medication intensified her insomnia. She immediately informed her providers and the Prozac was discontinued. This was the second antidepressant that had caused activation and worsening insomnia, a critical red flag for bipolar disorder that the providers failed to recognize. On November 25th of 2022, Nurse Paul prescribed 3 different medications, Ambien, Remeron, and Klonopin. And on November 26th of 2022, after taking them, Remeron, Lindsay experienced disassociation, perceiving the world around her as unreal, distorted, and distant. She was unable to determine what was real. She became disoriented, forgetful, confused, and disconnected from her body, from her own body. She was unable to drive and unable to be alone. Okay, Lindsay reported these alarming symptoms. What are you guys doing? Man, I'm on a live here, and I got kids in bathing suits running behind me. All right, pick it up where I'm at.
I'm gonna have her mom being like, "Hey, you guys, let my..."
Wow, you really had my kid on the internet there, naked, basically. Wow.
All right, you have to scroll. Lindsay reported these alarming symptoms to her provider on November 28th, 2022, noting she was struggling, sleeping only 3 to 4 hours, and feeling disoriented and forgetful. On November 29th, 2022, Lindsay began treating with nurse Gelada. Lindsay reported that she was, quote, anxious and frightened about what was happening and that she blamed herself. Nurse Gelada correctly considered a bipolar presentation and prescribed Seroquel, an antipsychotic and mood stabilizer. Now, I know those of you who have, well, never mind. I'm not going to talk about it. After starting Seroquel, Lindsay's condition took a dramatic turn for the worse. She developed suicidal ideation and began experiencing what she described as intrusive thoughts, which were actually auditory hallucinations. The voice said, quote, "I will not be the same. I want to die." Lindsay openly communicated her escalating internal turmoil to her husband, her parents, and her providers. She described her emotional state as emotionless and like a zombie, attributing this profound, effective blunting to the Seroquel. I mean, this is a huge problem. This is what people start to suffer when, when you start to take, antipsychotics, things of this nature. This is the first thing that people say. Who wants to keep taking any medication? I feel like a zombie. They have no emotion. It's like they're just not there. And I've seen it with my own 2 eyes. So on December 2nd, 2022, Lindsay reported to Nurse Gelada that she had lost 15 pounds, had no appetite, was experiencing panic attacks and confusion, and had a lack of attention over the past 4 days. On December 4th of 2022, Lindsay was so frightened by hallucinations that she called the New Bedford suicide hotline seeking help. She was told there was no emergency because she said she had no specific plan as to how she would kill herself.
Jesus. You fucking kidding me?
I mean, sometimes it works and sometimes it doesn't, because you don't want them forcibly admitting somebody for psychiatric help to a mental hospital when they're calling saying I have these suicidal thoughts. And so they've come up with a criteria for when it's the next sentence here. So but for a criteria of when someone needs to be like forcibly hospitalized. And that's one of the things they're trying to decide. Is it active or passive thoughts? But they're all things that all these doctors should be taking together to come up with the proper diagnosis. And I think that's a lot of the plan, a lot of the point here in the allegations. So scroll up a tiny bit.
Down, you mean like this?
Right there. On December 5th, 2022, Lindsay met virtually with an Aspire crisis support clinician, again seeking help. She was told she did not meet the criteria for inpatient treatment because she did not have a suicide plan. On December 6, 2022, Patrick attended an appointment with Lindsay and nurse Gelada. Patrick connected Lindsay's suicidal thoughts to the Seroquel. He told nurse Gelada that, quote, Lindsay is 10,000 times worse since she has taken medication. And he asked if they could, quote, get Lindsay off medication and start from scratch to see what is going on. He asked if there could be some mistake, like using the wrong medications. Nurse Gelada acknowledged, quote, it is possible. Despite this, Nurse Gelada continued to increase the Seroquel dosage towards 400 milligrams per day. Now, I'm see if they are going to get into this in the allegations, but typically you're also told, don't just stop. Don't, like follow what I'm telling you to. Trust your doctors. You cannot just like shut it all down and stop taking it. But let's see if that's something that was an issue here. On December 13, 2022, Lindsay remained deeply depressed, had no motivation, and still had suicidal ideation. She wanted, quote, this to be over. On December 15th, 2022, Patrick called Nurse Gelado's office to report that, quote, Lindsay has had a devastating week and that, quote, it was the worst day for Lindsay. She had horrible thoughts all day, end quote. Lindsay had auditory hallucinations all day, every day. She felt debilitated, not interested in anything, exhausted, and could not get out of bed. The hallucinations were loud and continued all day, saying, I will never be the same. I will never be me again. And you are damaged. You will never be the same. The only option is to die.
Jesus.
Lindsay told her husband, Patrick, I have thoughts of harming the kids. She also told her mother about these thoughts because she was in a psychotic state. Lindsay also had paranoid delusions that people could hear her thoughts and she would be locked in a hospital and have her kids taken away. Lindsay's escalating suicidal thoughts prompted a visit to Massachusetts General Hospital emergency room on December 20th, 2022, where she sought help. The ER suggested either admission to McLean Hospital or the partial hospitalization day program at Women and Infants Hospital in Rhode Island. You want to take over E, or you want me to keep going?
I can keep, or I'll pick it up. So E, Women and Infants Hospital and Dr. Diaz's failure to properly treat Lindsay. Hold on, let me blow this up for me. Okay, on December 20th of 2020, Lindsay admitted herself to the partial hospitalization day program at Women and Infants Hospital in Providence, Rhode Island, a program intended for patients with postpartum depression. This was yet another step Lindsay took to seek her help for her worsening condition. Lindsay's chief complaint at Women and Infants was, I feel numb and crazy depressed. She reported feeling, quote, crazy depressed, numb to all emotion. I can't feel love. That her, quote, life is becoming a disaster and that she couldn't, quote, feel fear and that she was, quote, messed up beyond repair. She had lost 15 pounds in a month, had no motivation, and reported that it, quote, it takes all the effort in the world just to breathe. Lindsay's Edinburgh postnatal depression scale score at Women and Infants was 23, indicating severe depression. Her generalized anxiety disorder 7 item GAD-7 score was 21, higher than the threshold for the most severe category. Despite these severely elevated scores, Dr. Diaz, the attending psychiatrist at Women and Infants, concluded that when Lindsay had no postpartum depression and rejected a bipolar disorder diagnosis because of, quote, no history of hypomania or psychosis or family history. What the fuck?
I don't understand that when it's a postpartum bipolar. Like, I understand them being like, well, there's no family history of bipolar disorder, so this probably isn't, but postpartum depression, you can be the
This
first to
woman is
have
a
it.
quack.
Right.
Is that
Right.
like real?
You've got all the
What
symptoms
does
of
she
this
think she
disorder.
has? Does she think that she's malingering? Wow, that
Oh,
is insane. That is absolutely insane. This conclusion. What are you doing?
it wasn't allowing me to pull, so I had to change us back to this setting here where we're
Oh, did
smaller.
you have to switch places? Did you have to be?
No. It wouldn't allow me to pull the
Because
like, if you're
I've
gonna
got it
go on a
blown up,
rant,
so I
I'm gonna
can't
do
tell.
that. You
Oh
know what I
yeah,
mean?
yeah. That was a short rant. So this conclusion was negligent because Dr. Diaz failed to obtain an adequate history. Dr. Diaz's own notes documented that Lindsay's sister had experienced postpartum anxiety, a relevant family psychiatric history that should have been explored. Had Dr. Diaz properly inquired about Lindsay's early postpartum period, she would have learned about the hypomanic episode that began immediately after delivery. Dr. Diaz also failed to recognize that Lindsay's providers had previously considered bipolar disorder, as documented in Lindsay's record, stating that she was started on Seroquel and a concern for bipolar. Wow, these doctors, man, are like unreal. Like, oh my God. Like I don't know. Like I don't, whatever. I'm not going to get into a long trope about doctors. Dr. Diaz accepted Lindsay and Patrick's belief that her symptoms were due to over medication and recommended weaning Seroquel. The clinical team at Women and Infants posited that Lindsay's symptoms were, quote, more pharmacologically induced than purely depressive, end quote. Dr. Diaz's assessment plan documented that the WIH DHP is not a suitable treatment facility for Lindsay, yet Dr. Diaz failed to recommend or arrange appropriate alternative treatment, and instead discharged Lindsay after only 1 day of treatment with inadequate follow-up care. Women and Infants Hospital determined that its day program was not appropriate for Lindsay and reached out to Nurse Cholada to discuss Lindsay's care. Nurse Cholada did not respond to them. Dr. Diaz and Women and Infants' negligent failure to properly evaluate Lindsay, obtain an adequate psychiatric history, and recognize the signs of bipolar disorder with postpartum onset resulted in a missed opportunity to provide appropriate treatment. Their recommendation to wean Seroquel without providing a proper alternative treatment plan or ensuring adequate follow-up care contributed to Lindsay's further deterioration.
So before we get into F, I just want to mention what Hildo44 says. As a depressed person, everything you guys just read about her, it's true. Getting treatment is hard. It took me 2 years to see a psychiatrist. I don't know what period of time that was that you suffered through this, Hildo, but I can tell you right now, the waiting list is extreme. It is extreme. People are having such a hard time getting mental health evaluations and treatment right now. It's crazy. It's crazy. All right, F. McLean Hospital and Dr. Goodhart's failure to properly treat Lindsay. Do we know? Do you have this on another screen where you can, or that a screen that you can duplicate? I'm wondering when the youngest was born.
Um,
You look for that, and I'll read
okay.
it. But if you change it on our screen, yeah, you just changed it for us.
All right, hold on. I'll find it.
Okay.
But I
So,
won't be able to scroll as well.
all right. So while you're doing that, I'll just look and see if there's any other comments we'll talk about. Well, because I want to find the answer to that while we're going through all these dates.
The baby was 8 months old. That I know.
Okay. So, all right, we can keep going. Kate Coco, Zegtress 2, welcome. Family hug. All right, so that's all I needed to know, babe. Following the Seroquel reduction recommended by Women and Infants, Lindsay's suicidal ideation resurged. By December 29th, 2022, Lindsay told her husband, "I can't tough it out anymore. I need to go to McLean." On December 30th, 2022, Lindsay went to the Mass General Hospital emergency room, which suggested admission to McLean Hospital. On December 31st, Lindsay admitted herself to McLean Hospital, the nation's top-ranked psychiatric hospital, due to her severe depression and suicidal ideation. Lindsay's admitting symptoms included passive suicidal ideation, feeling detached, hopelessness, depression.
Callan was born May 26, 2022.
Okay. No appetite or energy to perform activities of daily living, no motivation, racing thoughts, inability to organize her thoughts, memory problems, anxiety, and insomnia. Her insight and judgment were documented as, quote, limited. McLean placed Lindsay on a locked unit with 15-minute suicide checks. However, the care she received was grossly inadequate. She was admitted on New Year's Eve, and there was a, quote, skeleton crew because of the holiday. Patients spent their evening doing puzzles and coloring. Nurses stayed behind a desk and glass. Lindsay did not see a doctor until January 3rd, 2023, 3 days after admission. On January 3rd, 2023, the doctor advised Lindsay to stop Seroquel and benzodiazepines and prescribed trazodone for sleep. On January 4th, 2023, so that's just it, cold turkey, stop. On January 4th, 2023, Lindsay asked if she could go home for Cora's birthday. Because her thoughts had improved since the Seroquel decreased, she was approved for discharge. Lindsay was discharged from McLean Hospital on January 5th, 2023, after only a 5-day stay. Dr. Goodhart authored and signed the psychiatric discharge summary, approving Lindsay's release despite her documented, quote, limited insight, judgment, and suicidal ideation. Lindsay was returned to the care of the same outpatient providers who had been providing allegedly substandard care. After discharge, Dr. Goodhart from McLean called Lindsay and spoke to her for only 10 minutes, offering names of antidepressants. The staff at McLean suggested amitriptyline, yet another antidepressant, the very class of medications that had repeatedly caused Lindsay to have adverse reactions. When Lindsay was discharged from McLean's, she thought, quote, I was just in the best hospital in the country, so there was not much hope. She decided she must appear like she was okay and, quote, had to do her best. Dr. Goodhart and McLean's hospital negligent failure to properly evaluate Lindsay, obtain an adequate psychiatric history, provide sufficient inpatient care during her brief admission, and ensure appropriate discharge planning and follow-up care directly contributed to the tragic events that followed. Dr. Goodhart, as the discharging physician, approved Lindsay's release after only 5 days, despite her documented limited insight and judgment and her ongoing severe symptoms. So G is continued deterioration under Dr. Tufts' care. Do you want to take over, babe?
Yeah, Lindsay returned to treatment with Dr. Tufts on January 6th of 2023, the day after her discharge from McLean. Tufts diagnosed Lindsay with, quote, chronic major depressive disorder, single episode, moderate. She recorded that Lindsay's psychiatric condition was deteriorating and that her medication was not effective. Despite her poor condition, Dr. Tufts met with Lindsay for only 17 minutes. At Cora's birthday party on January 7th of 2023, Lindsay was not herself. She smiled but could not converse. She avoided talking, could not make sense of what others were saying. Lindsay's hallucinations resumed within 1 week of her discharge from McLean. On January 10th, Lindsay returned to Dr. Tufts and switched to Valium for a benzodiazepine taper. Dr. Tufts indicated that at some point we will add an antidepressant. On January 16th, 2023, Lindsay was still experiencing debilitating depression and had to force herself to do anything. The hallucinations continued. You should harm the children. You should kill yourself. You will never be the same. The only option is to die. She felt like a zombie. Dr. Tufts prescribed amitriptyline, another antidepressant, at 10 milligrams per day. On January 20th, because Lindsay was having such awful thoughts and was so numb and emotionless, she researched what is a psychopath to see if she was one and whether there was a cure. On January 23rd of 2023, during another 17-minute appointment, Lindsay reported being, quote, a little more anxious with heart racing and more AM anxiety. Dr. Tufts recorded that Lindsay's mood is the same flat anxious and that she had no motivation and was numb and had to force herself up and out of the house. Her sleep and medication efficacy were poor and her insight was poor and her psychiatric condition generally was unchanged. Dr. Tufts increased the amitriptyline to 20 milligrams per day. That night, Lindsay did not sleep. January 24th of 2023. On January 24th, 2023, Lindsay woke up severely depressed with suicidal thoughts. She gave the children breakfast. She took Cora to the pediatrician because Cora complained of a stomach ache. Later, she went to the backyard with the children, built a snowman, and sent a picture to Patrick and her mother. The suicidal hallucinations continued all day nonstop. Later in the afternoon, the voice began saying, "You should harm the children." Lindsay thought about dinner and realized she had not prepared anything. She asked Patrick about takeout. She looked at a map to see how long it would take because she did not want to be alone and needed help. As soon as Patrick left to pick up the food, there was a loud, demanding, repetitious voice. "This is your last chance. Kill the children so you can kill yourself. This is your last chance. You have to kill the kids so you can kill yourself." Lindsay felt a force come over her.
Okay, so just to pause right here, that's a very big difference than what the state is alleging.
Yeah.
The state is alleging Lindsay placed this order and sent her husband off to the forest, the furthest place on purpose. And the picture being painted by this is that the plan didn't come into effect until the voices started happening after that, saying now, 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 now.
Lindsay experienced command auditory hallucinations. A, quote, demanding, powerful male voice explicitly ordered her. She felt an overwhelming and irresistible compulsion to comply, entering a dissociative dreamlike state where her physical actions felt utterly disconnected from her conscious volition. She perceived her body was just acting and she was merely watching herself do it. She reported she had no choice but to follow these compelling directives. Lindsay described, quote, "I lost all control. My body started acting without any control on my part. I was just following commands, all action. The voice demanded action." Lindsay proceeded to strangle each of her children, uttering, "Go to God, baby." Following these acts, she undertook a severe suicide attempt, ingesting a substantial quantity of various medications, self-inflicting lacerations to her wrist and neck, and jumping from a second-floor window approximately 20 feet below to the ground. Lindsay suffered catastrophic injuries, including a thoracic spinal cord injury, resulting in permanent paralysis below the sternum. She also suffered multiple closed fractures of her cervical and thoracic vertebrae and multiple rib fractures. Corin Dawson died on January 24th, 2023. Callan succumbed to his injuries and died on January 27th of 2023. Lindsay consistently maintains her actions were compelled by a hallucinatory voice, not a conscious decision, and expresses a profound, endearing love for her children. Expert psychiatric opinions. Dr. Margaret Spinelli, clinical professor of psychiatry at Columbia University College of Physicians and Surgeons and founder of the women's program in psychiatry at Columbia University Medical College, conducted a comprehensive forensic psychiatric evaluation of Lindsay. Dr. Spinelli met with Lindsay for 5 hours at Tewksbury Psychiatric Hospital on June 11th of 2024 and subsequently spoke with her by telephone for 3 hours on September 6th of 2024. Dr. Spinelli also interviewed Patrick Clancy, Lindsay's sister, Allison Olga, and Lindsay's mother, Mrs. Musgrove, and Lindsay's mother-in-law, Susan Clancy. Dr. Spinelli diagnosed Lindsay with bipolar disorder 1, a severe with psychosis and anxious distress with postpartum onset. Dr. Spinelli concluded that Lindsay had a baseline bipolar disorder with minimal symptoms after her second childbirth and that her symptoms worsened after her third birth when she was prescribed an antidepressant. Dr. Spinelli noted that, quote, an antidepressant medication can create manic or hypomanic symptoms and mood instability in one who has bipolar illness. This is a well-known response for a person with underlying bipolar disorder. Dr. Spinelli opined that the providers never seemed to communicate with one another and that no one ever asked her to describe the content of her intrusive thoughts, which were in fact hallucinations, and that Lindsay was repeatedly given antidepressants, quote, instead of a mood stabilizer. Dr. Spinelli specifically commented on the failures of multiple providers regarding the initial Zoloft reaction. She noted that if practitioners had recognized the hypomanic activation after Zoloft, a second or third antidepressant would not have been tried. Regarding women and infants, she noted that Dr. Diaz, quote, did not review symptoms of last pregnancy in this postpartum period and did not review hypomanic episode immediately after delivery, which was the beginning of Miss Clancy's postpartum psychosis. Spinelli concluded she did all that she could to obtain the appropriate treatment. Dr. Paul Zeibel, a forensic psychologist, also conducted extensive clinical interviews with Lindsay and her parents. Dr. Zeisel was the initial forensic expert to engage Lindsay in the immediate aftermath of the incident. Dr. Zeisel concurred with the assessments of Dr. Spinelli and Dr. Philip Resnick. Dr. Zeisel opined to a reasonable degree of psychological certainty that Miss Clancy's clinical course was significantly complicated by polypharmacy and the involvement of multiple prescribers, which in effect obscured an accurate diagnosis and appropriate intervention and treatment. Furthermore, the psychotropic medications she received appeared to have paradoxically exacerbated her underlying psychiatric vulnerability, precipitating a state of manic psychosis characterized by compelling command hallucinations. Zeisel noted that Lindsay's parents conveyed profound shock and devastation at the depth of her psychological decompensation, indicating a prior lack of complete comprehension regarding the actual severity of her underlying illness. This underscores how the medical providers failed to adequately communicate the severity of Lindsay's conditions or take appropriate action. So the defendant's violations of the standard of care.
So before we get there, how much longer is this complaint, by the way?
We've got not too much, like probably 4 more pages because it's 20.
All right, so let's actually finish this and then I'll make my comments. All right, defendant's violation of the standard of care. The standard of care requires defendants to obtain complete psychiatric history, including detailed inquiry into Lindsay's mood and symptoms during and after her prior pregnancies. Had any of the providers done so, they would have learned of the hypomanic episodes that followed her second and third deliveries, which were critical indicators of bipolar disorder postpartum onset. The standard of care required defendants to recognize that Lindsay's severe adverse reaction to Zoloft, characterized by activation, worsening insomnia, and racing thoughts, was a red flag for bipolar disorder. The standard of care further required that after a second antidepressant, Prozac, caused similar activation, defendants should have diagnosed bipolar disorder and prescribed a mood stabilizer rather than continuing to try antidepressants. The standard of care required defendants to conduct appropriate testing, including blood plasma levels of medication, to determine why Lindsay was having adverse reactions to relatively low doses of medication and why she was a slow metabolizer. All right, so that right there is something that they're saying a slow metabolizer is the medicine takes a long time to work. Okay, so for whatever reason. The standard of care required defendants to follow the, quote, start low and go slow principle, which when prescribing medications, particularly given Lindsay's demonstrated sensitivity to psychiatric medication. Instead, defendants added and accelerated medications in an ad hoc manner that radically increased the risks to Lindsay. The standard of care required defendants to inquire into the content of Lindsay's intrusive thoughts, which were actually auditory hallucinations. So that's a big difference. One is like intrusive thoughts, which everybody has. You know, if you're paying attention to that annoying voice in your head, You're probably having some intrusive thoughts. That's different than hearing a voice telling you stuff that especially when you're hearing it in a man's voice, not your own voice. So had they done so, they would have recognized the psychotic nature of her symptoms and the danger she posed to herself and her children, including the danger of postpartum psychosis. The standard of care required the defendants to coordinate among themselves with other treating providers. Instead, the providers failed to communicate with one another, and Nurse Jolada did not even return women and infants' call to discuss Lindsay's care. The standard of care required defendants to seek collateral information from Lindsay's family members, who could have provided crucial information about the severity of her condition and her functioning at home. The standard of care required defendants to recognize that Lindsay, as a patient suffering from severe postpartum mental health disorders with suicidal ideation, posed a risk of harming not only herself, but also her children. The standard of care required Dr. Goodhart and McLean Hospital to provide adequate inpatient care during Lindsay's brief admission, properly evaluate her condition, and ensure appropriate discharge planning rather than discharging her after 5 days with, quote, limited insight, judgment, and suicidal ideations, back to the same providers who had been providing inadequate care. The standard of care required Dr. Diaz and women and infants to properly evaluate Lindsay, obtain an adequate psychiatric history, including inquiry into her early postpartum period, and recognizing the signs of bipolar disorder rather than dismissing her severe depression scores and recommending medication changes without proper follow-up. Defendants knew or should have known that Lindsay presented a real, clear, and present danger of harm to herself and her young children. Defendants' collective failures to comply with the standard of care, more likely than not, directly and proximately caused the injuries suffered by Lindsay, including Lindsay killing her children and attempt to kill herself. So you're saying there's like 3 more pages?
Yeah, it's
And
like,
I think we can kind of summarize these. So first you have negligent medical malpractice and personal injury. And they basically just say as a direct and proximate, result that this happened. They failed to exercise reasonable care in caring for her and violated the standards of medical practice.
yeah,
But some of these are actually important. Oh no. Well, those are her injuries, right? Not that.
it's all of them. It's the loss of her 3 children.
Go ahead.
Development. So as a direct and proximate result of the negligence of the defendants, Lindsay suffered severe personal injuries, including but not limited to the loss of her 3 children, Cora, Dawson, and Callan, the development of severe postpartum psychosis with command auditory hallucinations, a thoracic spinal cord injury resulting in permanent paralysis below the sternum, multiple closed fractures of the cervical and thoracic vertebrae, multiple rib fractures, neurogenic bowel and bladder dysfunction, impaired mobility, requiring the use of a wheelchair, and severe psychological trauma.
And they just say that how their conduct was a gross negligence and reckless indifference to the health, safety, and welfare of Lindsay, showing a reckless disregard for the consequences that they knew or should have known would have resulted, and that she's entitled to
damages.
Damages. So that's count 1. Count 2 is loss of parental consortium. Now, again, this is the loss of her children. So they said as a direct and proximate result of the negligent, recklessness, and gross negligence of the defendants, Lindsay has suffered and will continue to suffer the complete and permanent loss of the companionship, consortium, services, society, comfort, guidance, counsel, and advice of her children, Cora, Dawson, and Callan. As a result, she's entitled to damages determined at trial. This is different.
Spousal consortium.
Oh, okay. So as a direct and proximate result of their negligence, recklessness, and gross negligence, Lindsay has suffered and will continue to suffer the loss of the normal marital relationship with her husband, including loss of companionship, consortium, society, comfort, guidance, counsel, advice, and conjugal fellowship as a result of the devastating impact of the events of January 24th, 2023 on her marriage. Count 4 is
vicarious liability.
Okay, so this is only against some of the defendants. So you've got this Astor Mental Health, the South Shore Health System, McLean Hospital, Women's and Children, and the allegations keep going. So you've got that Dr. Tuff was an employee or agent of the Astor Mental Health, acting within the scope of his employment. Nurse Joletta at South Shore, acting in the scope of her employment. Dr. Goodhart at McLean Hospital, acting in the scope of her employment. And Dr. Diaz at Women and Infants Hospital of Rhode Island, acting in the scope of her employment. And under the doctrine of respondent superior, they're holding, and then they just go through each of them. Astor Mental Health for Dr. Tuff, and each ones that they just mentioned are all vicariously liable. And that is the end.
Yep, that's it.
So here's what I wanted to say about this. Typically, you're like, oh my Lord, don't go to a civil lawyer and file some complaint like while your criminal case is pending, like God forbid. But I think that's why Rosemary is involved here. You need a criminal lawyer who knows that what you say here, sure as shit, better lay out a legally recognized criminal defense. So if we go back to, babe, and I'll put it back up, it's just a couple of paragraphs here, because she doesn't have to put every single fact in here, but I'm gonna keep going.
Where do you want me to go? One of the
Way
counts,
up, I'll tell you,
or the facts?
All right, slow down. You know what? Can you control F to I think she said like control her body.
What are you looking for?
Like, and I think it would be lower than this. We might have scrolled right past it, but I think she said words like control her body, all the things where she walks through how she felt, that she wasn't making her own decisions, that she had no control. You know what? Write male voice. If you can search control F.
Okay.
It might not be searchable.
Yeah.
Don't search it. Don't search. Just keep going down. I'll find it.
I'll never be the same. Okay.
Nope,
We're getting right here. There. So
no, I know, but
it
keep
starts
going.
here.
Right, but I want to get specifically to keep going. Keep going. I think it must be after all of this. Way down before you get to
it's coming. It's coming. So there's not much hope.
Oh.
All right, so it's coming. The only option. Okay.
Nope, I got it. Keep going.
Hallucinations continue. What is a psychopath?
Okay, I think it's this January 24th, 2023. That's where it is.
Oh, so January 23rd, she was.
No, I mean this H. Okay, so here it's basically like these couple of paragraphs. 77. You've got that the hallucinations continued all day. You should hurt the children. The thing about that she thought for dinner, about the fact that she hadn't prepared it. So that's covering that, right? She's basically getting a roadmap for the criminal defense attorney as well, because the criminal defense attorney is now boxed in. This is your story. These are your facts. This is what happened this day. This is what she felt this day. This is what she did this day. This is why she said words she said, or what, this is the roadmap. And nobody can go outside of this now. And having a, highly, intelligent woman and criminal defense attorney, make sure that this is all right and this is locked in stone. Thank God. Thank God. So then you have that as soon as Patrick left to pick up the food, there was a loud, demanding, repetitious voice. This is your last chance. Kill the children so you can kill yourself. Repeating that. And it says, Lindsay felt a force come over her. Lindsay experienced command auditory hallucinations, a demanding male profile voice, explicitly ordered her. She felt an overwhelming, irresistible compulsion to comply, entering a dissociative, dream-like state where her physical actions felt utterly disconnected from her conscious volition. She perceived her body was just acting, and she was merely watching herself do it. She reported she had no choice but to follow these compelling directives. Lindsay described, I lost control. My
All
body
control.
started all control. My body started acting without any control on my part. I was just following commands, all action. This voice demanded action. So that's it right there. That is the entirety of her defense. And you can bet, I mean, look, maybe Rosemary didn't have to research a thing. Maybe she knows exactly what the law, what the law has said as far as when situations are compulsion. But I can tell you, if this was me, that's where I would have been starting with criminal cases, talking about the elements of compulsion, when the courts have said that it's been met, what has to be met to make sure that you know, your allegations fit into that. And again, you don't need every allegation in here. But when you have a criminal lawyer drafting it and that we've seen it in what was the case that we just had where they're bringing in the civil lawyer, the boat accident,
Yeah.
right?
Yep.
And they're like, hey, you don't need to put every fact in here because I didn't say that doesn't mean that's not the case. You know what I mean? So she's sure to put everything in very, not everything, right? Like still don't need everything, but enough to capture the main elements here so that no one could ever come back to this document and say, you didn't say it there. This is some revisionist history. If that was true, why didn't you say it there? If that's how you felt, if that's what happened, why didn't you say it there? You didn't mention that this didn't happen until after he was on his way to dinner until, so that kind of thing. So this is like, because I'll tell you, if you sat here and said to me, oh, this woman who's got this case is about to file a civil suit, I'd be like, oh, Lord, no. Lord, no. What kind of civil attorney is doing what now? So,
yeah, but
God,
Kevin Reddington's definitely in communication with Rosemary. That's
no,
Lindsay's trial lawyer. Yeah,
for sure.
This was done part and parcel. This was planned. And the thing about Lindsay's case is that we don't have to take her word for it. Like there's medical records. What she tried to do is established through medical records, through phone records.
And there's a statute of limitations.
Through her parents, through her husband, through everybody that knew her. Like this isn't something that she was keeping to herself, that we have to guess whether or not she's full of shit. This was happening. This did happen. And so what we want to get into last in terms of
and before we do that, I want to touch on some people's questions because look, people will look at this and be like, okay, I understand all of that, right? But is that enough? Because, I'm having conversation with your dad when I run down and he's like, is that enough? Because someone still has to jump. Like, yes, you're having the voices. Yes, it's the medication, but she still has to jump. Is it going to be enough? And that might be what this is, comes down to at a trial. But we have, first of all, Panda Bear became a new member. So welcome, family hug.
Family hug.
It's a hard one to come in on, but we're glad you're here. Hildo said, I only tried to unalive myself was when I was on the medication. The only time I think I tried to unalive myself, I was on the medication. We get treated like guinea pigs. And I hear you. Like I've seen it with friends going through it. I know how this works again. And just to tell you a little more about the story that we had that led to me 20 some years ago filing a suit against the pharmaceutical companies and the doctors was a family member by in-law, by marriage. We were all hanging out, and I must have been in my 20s, right? And he remembers a traumatic childhood memory and had like a breakdown right there, something that he just had blocked out his entire life. And he started acting so weird. We took him to the hospital. They gave him antidepressants. They gave him this, they gave him that. He came out a bipolar mess and went through the same thing where like he just looked like a zombie. And this was one, I mean, he went in there after I experienced a traumatic memory and had a little break. And this is how he comes out, a zombie.
That's exactly how we described him. Like
Right.
every aspect of his personality was gone.
Wiped.
He was like a shell of his former self. Like there was no part of him that existed anymore in any capacity. Like there was no, trying to get through to him with words. Like there was no ability to be able to break through the medication psychosis that had developed with him, because it was like impervious. Like there was no way to communicate with him meaningfully about anything.
And then the medication triggered like a real bipolar episode. And then it was like, well, once you have a bipolar episode, you're bipolar. So now that's when it leads to they're being treated for the bipolar and he's a zombie, and he did have outbursts and I mean, obviously nothing quite this severe, but we've seen it, and it happens with everyone, just as Hildo's describing. And as we'll see with the portion of this video that Bob's going to play from one of the hearings in the criminal matter in this case.
It was 2 days ago. It was, leading up to trial, the motions in limine. We skipped a bulk of it. We just wanted to kind of focus on Kevin Reddington and his argument. And I'm here to tell you, Kevin Reddington is a lawyer not to be messed with. This guy is another phenomenal criminal defense attorney. He's got 40 plus years. He's tried over 100 homicides. High profile guy. Like you'll see it immediately. He commands the room.
I was just going to say that.
He knows what
he has a commanding authority. He knows what he's talking about.
His comfort level is like, if you're going to compare, say, for instance, Seligson the other day in front of the judge, compare and contrast with how this guy approaches this judge. So I'm going to pull it up. We're going to listen to about 10, 15 minutes of this because it's compelling. And what they're arguing is compelling. Babe, I started a little earlier, so the judge is asking about what he wants to get into. So he first addresses the state briefly, and then Reddington gets into it.
Okay.
All right. All right.
And Bob, what did we note about what the state decided to do in this case?
What do you mean?
Put two female prosecutors at the table. There's not a male table.
Right.
That is a conscious decision.
Calculated
decision. Yes. Thank you, babe. And it's unusual. It's much more typical to have a male and a female. And there's a lot of good reasons for that, because people relate to a male and a female differently. But here they chose two women.
Yep. All right. Let's roll.
If we can't. Can you hear voices, babe?
You guys can't hear it?
No.
All right, hold on.
The only reason I knew, because I heard like a fuzz, but then I saw the closed captioning.
Yeah, the sound's actually pretty good on here. Let's see. Got it. Okay. I'm gonna flip it back a couple.
Language that's suggested. All right.
I think that concludes the motions.
All right. And then there's one last motion that was filed yesterday. Did Commonwealth have an opportunity to review that?
Your Honor, I briefly looked it over. I would suggest that we shouldn't even broach this motion in that it violates Rule 14 discovery, and that these individuals have been identified by initials only with no other information, no statements of the witnesses, no indication of what these witnesses have to offer or the background. And it's 1 week prior to trial. So I'd ask that it just be denied on its face.
Well, I understand that, but it's been raised. So I'm going to hear from the Commonwealth, and I'll hear from the defendant first, then from the Commonwealth. I'm sorry, and then I may have to take it under advisement myself, and it may be the argument that there's just not enough here for me to make a decision is there. But I think I want to give the defendant the opportunity to argue this. So, Mr. Reddington, this is the motion to eliminate to permit testimony from witnesses who have themselves been, according to the motion, victimized by the medical system regarding the issues of postpartum depression and postpartum psychosis.
Yes, Your Honor, thank you. Your Honor, as I say in the affidavit, and as you can well imagine, I have been contacted by many people who have, in a very moving, emotional fashion, advised me of these horrific issues that they've been dealing with postpartum depression, postpartum psychosis, hearing the auditory commands, having intrusive thoughts to hurt or kill their partner or their children, infanticide, as a result of postpartum psychosis, medication issues, contributing to the postpartum depression, postpartum psychosis. And it's so easy for us as a society to say in a troubling case like this, oh my God, she's guilty, throw away the key, put her in jail and just be done with it because it makes everybody feel better. It's a feel-good reaction that, okay, somebody has been punished because of doing a very bad thing. But as we know, when you're dealing with the issues of lack of criminal responsibility, I don't like the term insanity, but nevertheless, when you're dealing with somebody who is suffering from a medical a defect or a disease, and they have actually experienced something that is so outside the ken, if you will, of jurors, of normal people, for us to believe that somebody's hearing voices, the initial reaction from any one of us, I think, in this courtroom would be, come on, you're not hearing voices. What do you?
I mean, he is nailing what I say on this channel constantly about mental defects and mental health issues. That people that don't have either personal experience with it, either themselves or with family members, just have a tendency to think that it's bullshit, you know, and that is why we want to cover this trial so desperately. And we are going to cover this trial because I'm tired of it. I'm sick of it. You know, when I posted this yesterday, I had somebody like, oh, she sent him to the furthest restaurant 9 minutes away. I'm good. You know, I'm like, you know what? You're the chick who's trying to say that Koberger didn't kill the 4 kids that he admitted to, right? You know, I'm good. Like, you know, thank God you're not a juror. You know, but like that particular person is kind of indicative to the population in general, you know, and this trial is important. It's important. And the discomfort that you're going to feel watching it is equally important for you to feel because it's not a comfortable situation. And he's nailing it on the head right here. He's absolutely nailing it on the head. It's easier to say, wow, man, I mean, she killed her own children. It's unforgivable. Throw her in jail and throw away the key. That's it. We're done. Clean our hands of it. That's not how this thing should work, because there are times when our minds, which are so complex and we have such a little understanding of it, even the most brilliant doctors and scientists only have a very limited knowledge of how our mind works.
Practicing medicine.
I mean, so I really wanted you guys to hear him. He's impressive. This is going to be a hell of a
Wait, pause it again.
People outside, and
What?
they have.
I just want to make sure because you started it and then you talked over him a little bit.
Yeah, I flipped it back.
Sorry.
actually experienced something that is so outside the ken, if you will, of jurors, of normal people, for us to believe that somebody's hearing voices, the initial reaction from any one of us, I think, in this courtroom would be, come on, you're not hearing voices. What are you talking about? You're making this up. You're trying to avoid responsibility. But it is true, and it happens, and it is an affliction that people have put up with. And if they are permitted to testify as their experience themselves as to postpartum depression, psychosis, the concerns and the fear that a woman has, and I say as a woman has, because guys don't know about this. You know, we're so quick to go out and we're mighty and strong. We have many beers, and we're real quick to say, throw away the key on it. But a woman who has suffered and has put up with this affliction should be able to testify and say, probably in an emotionally charged fashion, very credibly, I too have heard these command voices. I too acted on the command voices. I too have had insomnia. I too have had hedonism where I don't even care if I live or die. I have no emotion. I can't feel. I can't laugh. I can't love. I can't hate. And I think that that is important. Now, before I disclose the identity of these people, it seems to me that what I have to do is present the general legal issue to you as a preliminary gatekeeper almost, where you would say, hypothetically, I think upon sufficiency of proof, it is admissible. And I am inclined, you the judge, to allow that evidence before a jury, at which point I would then, of course, disclose the identity of the people with their knowledge and consent, their medical backgrounds, and the government could then send their cops out to interrogate them or intimidate them or talk to them, or do whatever they want to do. But if they get on that witness stand, they have.
Here we're going to read.
Bob and I were watching this and we busted out laughing. I'm like, I fucking love this guy because I mean, he's not gonna him and Rosemary seem right on par with each other. They're calling it like it is. They're saying it like it is. And every one of us fucking knows they're gonna interview, interrogate, harass, whatever. So I mean, that
We're
right
gonna-
there, I was like, this guy's not fucking around.
We're going to listen to it one more time.
Yeah.
And I am inclined, you the judge, to allow that evidence before a jury, at which point I would then, of course, disclose the identity of the people with their knowledge and consent, their medical backgrounds, and the government could then send their cops out to interrogate them or intimidate them or talk to them or do whatever they want to do. But if they get on that witness stand, they have credible evidence to give. So it's a two-part. I can't really give their names and addresses without knowing. You may say, as a matter of law, it's not admissible. Somebody's individual experience with a narcotic, with a drug, with a disease or a defect is not admissible in a sense of the specifics of a trial. And if that's the case, then it shuts down the issue and that's the end of it. But I had to raise the issue preliminarily.
Thank you, Your Honor. I'll incorporate what I said before about the Rule 14 and the lack of notice in the 1 week prior to trial, but also defense counsel cites no rule of evidence that would allow for the admission of layperson testimony about these issues. He cites to the battered woman statute, but in that statute itself, it refers to expert testimony, not laypersons saying, I had this experience, so the defendant must have as well. And then I think what we come to is it becomes more prejudicial than probative in that say you allow 16 people to come in and testify to that, then the Commonwealth gets to rebut that with their own witnesses, women who suffered from postpartum depression and psychosis, who did not kill their children, who locked themselves in a room to keep themselves from harming their children, who got in a car and drove away so they didn't harm their children. And so then it becomes a trial within a trial. And it's more prejudicial than probative. There's no rule allowing the admission. And it would delay the trial. in all honesty, because then we would be filing a motion for discovery on these witnesses, their medical records, having them interviewed by police, which would take time. So I would object to this motion.
I'd like to know who these people are that were locking themselves in rooms and getting in their cars to avoid killing or hurting their children.
Just go on Facebook, they're all over.
But isn't that the whole problem? I think what the Commonwealth is saying, that this isn't just a trial within a trial. It would be 16 trials within this trial. I understand the argument, especially the kind of comparison to the battered women syndrome. But as those cases develop, I'm sure Mr. Reddington may remember, as those cases that became more and more admissible, it really hinged a lot upon the testimony of experts. And in this case, I anticipate there's going to be experts that are going to talk about the reality of this postpartum depression and postpartum psychosis. So that's coming out.
And I understand the state's position on that, and I think that there's some truth to it. They would be able to rebut with those types of witnesses. But at the end of the day, if you're a juror, would you rather hear from some expert who studies people that are experiencing these types of things, or would you rather hear from people that have what's going to have a bigger impact in terms of moving the needle for you as an individual who might have walked into that courtroom with that mindset, like hearing voices, what kind of bullshit is this? She's just trying to avoid criminal liability. Like, if that's where your baseline is, what is moving the needle more? A parade of people that have lived it, experienced it, are willing to get on the stand and testify to it, or having an expert talk about it
But
who
then
hasn't experienced it?
Right. So Bob and I had this. Should we finish what he says? Well,
Yeah.
I'll just say, but Bob and I had this conversation off air, and I was like, but to the prosecution's point, that might actually hurt the defense. If the the defense wants what the prosecution always gets. The prosecution always gets that emotional testimony, that emotional draw to the jurors, in a sense where the defense never gets it. And this is the defense coming up with a way where he even said it. It'll be emotionally charged. They want people to see, like Bob's saying, from other people, from women who are normal, love their families, love their kids, that they suffered this, that they went through this, and how they felt. They want that emotion from real people that you just can't get from an expert. But I do think the possibility, let's just say if the state is able to put on a bunch of people who say, well, then I locked myself in the room, I tied my wrist to the vent in my, I did something that could hurt the defense, because the whole point, and I think that's where the judge is coming down, that different people are going to respond differently. They're not going to have the exact same personal makeup and, to respond to the medication. So I don't think that the judge is off base here. And I do also believe it would be, talk about a trial within a trial. And you've got to talk about their entire, medical history, their family history, what exactly they did. It would be a lot.
It would be a lot. There's
right.
no question about it. But, look, in this case in particular, the state has the ultimate emotion card. The
Right.
woman unalived her 3 children. Like in terms of an emotional card that can be played by the state, I don't know that there's one that's more significant than that. Like they have that. That's looming over this trial from the get. And I get it. I understand both sides of the argument, notwithstanding that, in terms of what the more powerful evidence to get people to finally start understanding that this shit is real, that it exists in the world, that it does happen to people, that people experience it, that people do awful shit to themselves and other people that is not of their own volition. And you know, to hear it from somebody that's not some paid gun, hired gun, sitting up there spewing a bunch of DSM 4 or 5, whatever the hell they're on now, where I just don't know that that moves the needle for people the way that it would be the other way. And like you said, I see the problems with it. You know, at the end of the day, you know, it does turn into a trial within a trial because they put on their rebuttal witness, say, okay, well, yeah, she got in her car and she drove 500 miles away, so she couldn't harm anybody that was involved with her in her life. And that's what she did. Well, you know, and then the defense is saying, okay, well, you know, did she check herself into a hospital first? And they, you know, like let her go because she wanted to go to her kid's birthday despite knowing everything that was going on with her? You know, it's like all that shit.
And
And
did she have the same cocktail and did it affect the same way? But here's part of the point to Bob, to both of ours point about this whole emotional thing that the prosecution just sinks into and it doesn't matter. You would think there would be a process in the law where a defendant can choose to concede the elements that they caused the death of these people so that there is no part of the trial for that. No part of the trial for that. They can put in as a stipulation what she did and how she did it and how they died, how much time it took, things like that. You don't need pictures of unalived little babies. You don't need to be like, come on, you're supposed to be for the people, but you do not care what these pictures that are not necessary to determine was she legally responsible, you know, but you don't care that is going to impact those 12 people on that jury. There are trials where jurors have to leave and get psychiatric care because of the pictures they're shown, because of the testimony they hear. We don't need a trial about how wonderful these children were, about the with the pictures of all of their injuries. We don't.
Because you know who knows it more than anybody else in that room? Lindsay Clancy. That's who knows how wonderful her children were. I mean, her history with her children speaks for itself. And we don't have to take her word for it. Everybody that was in her orbit will be in that courtroom testifying to what type of mother she was. You know, so it's like, I hope you all plan on watching this thing, and you should tell your friends and tell your neighbors to watch it, whether it's here or somewhere else. I don't care. You know, it's that important of a trial. It is a trial that it's a once in a lifetime trial for this judge, for these lawyers. It's that kind of career case. And Kevin Reddington has handled some bangers, but this is going to be a case that, because of the impact that we'll have moving forward, it'll be, you know, I see people talking about Andrea Yates, and that was 2001, 25 years ago. This case, if it comes down the right way, which is the way that I believe that it should be, which is,
reshape
I
the
mean,
law.
man, it is, you are asking a jury to do the hardest thing imaginable, saying, my God, this woman did the most unthinkable thing that person who is sworn by blood oath to protect did the unthinkable to her own children. But we have to find her that she's not criminally responsible for it because of what her mental state was. Like, I mean, it's a huge ask for 12 people. I understand that. You know, the lawyers understand it. The judge understands it. But God, man, it's got to take place. Like, this was always going to trial. This has to go to trial. This was never getting pled out.
No, what it could have not been, not charged.
That 100%.
Not
but
charged.
Then, you know, look, prosecutors, they're, you know, these gals, their boss is the elected prosecutor in that county. And when you have the public who sees this story on the news and is not digging in, is not watching Defense Diaries and getting a primer and learning about everything that was going on, everything that she tried to do to avoid this, you know, they've reached a conclusion. That's it. You know, so the prosecutor's office is acting on the behalf of those people, the uninformed, the torch and pitchfork crew, I like to call them. Those don't don't necessarily care about the facts and the evidence. They've already formed an opinion based, huh?
The DA is elected in Massachusetts, right?
Yeah, like
yeah.
Yeah, the
I
DAs are
think you're
elected.
talking about the judges or not.
Judges are appointed. DAs
Right.
are
All
certainly
right, let's hear the
elected.
rest of what the judge had to say.
All right, well, let's roll.
These are testimony that'll come from the experts, I think, on both sides. It doesn't seem like there's a question of whether or not postpartum depression or psychosis is real. I mean, all the experts seem to agree that it's real. So because of the ability to get the probative part of what those women would bring to the court, the experts can give that. And so I'm going to deny
They can't.
the motion at this time.
And I'll have to say, I agree. Although I would have liked it otherwise, I think it's the right.
I get it. I get it.
On the questionnaire,
Okay, so let's talk a little bit more about this. Let's go over everybody's questions because I think you guys all put out a lot of really, really interesting questions. So we've got Kathy, your realtor in Jersey. This is so sad. It is painful, but your reading is necessary. Praying it helps others. Thanks for your contribution, Kathy. So, and then Sean Broadwick asked the question, I know a JNOV, judgment notwithstanding the verdict, is rare. It is allowable for the judge due to mental illness to commit her. So if they went through the trial and they decided she was guilty, he could find in judgment that she is not guilty by, I know it's not by insanity here, but he could have to be, not guilty, period. Barons von Brackenfell, thank you very much for your generosity. It's Millie says, so sad, sounds similar to the Texas case of Andrea Yates in 2001, in which she killed her 5 kids. Bob, you just mentioned that.
Yeah.
Thank you. It's Millie. Adford
Thanks,
Dredd
Millie.
says, I'm from Florida. They don't have Baker Acts in Massachusetts. The way they said you have thoughts, but not plans to do it. Excuse me? Just call us back when you have a plan and we'll make arrangements for you. So you wait, they don't have Baker Acts? I thought
The Baker Act is a specific to Florida because it's an act that was made by the Florida legislature.
But Kelsey
He's asking if
Fitzsimmons-
they have the equivalent in
Kelsey
Massachusetts.
Fitzsimmons was involuntary admission.
5150, I think they call it in Mass.
Right. So, and what he's talking about is just that you get involuntarily admitted for mental health treatment when you're not seeking it yourself.
I mean, but she voluntarily admitted.
She was trying to get it right.
She went in, and then it was her kid's birthday, and she was feeling moderately better, to the point where she wanted to get out because she had been off the Seroquel for a few days at that point, so she wasn't feeling as crazy. And the doctor, instead of saying, "Yeah, you know what, I think we need to see this thing through,"
right? We got to get you on something that you're controlled when you get out. We can't just leave you because that's what happens with people with bipolar. You take the medicine, you feel like a zombie, you have no joy in life, or you just feel so much better. Sorry, apologize. I should have muted myself. So much better that you get off the medication. Then you're off the medication and there's no then all of a sudden, boom, you're in a manic episode. You're in a psychotic episode, whatever the case may be. So then we've got Adford Dredd came back. Maybe you're a new member. Maybe you haven't been a member before, but we've seen you around here for a lot.
We love you. We love you, Adford Dredd.
So sad. She exhausted all options. They failed her. Just South of History says, money and research for studying testosterone, but no money or advocacy for women's mental health. I'm a conservative. What are we trying to conserve, if not the health and welfare of our mothers and our children?
100%.
Amazing point, South of History.
100%. Yeah, let's spend a shit ton of money so guys can get boners.
Right. I was going to say, not even necessarily on testosterone, but just getting not being a limpy.
Yeah.
CU Buff's mom says, thanks for covering this. This case and my own family members' experience is why I'm in grad school for forensic psychology. So very sad. I went to high school with Reddington's daughter. He's a great lawyer.
He is a great lawyer.
I mean, he seems it to us, At for Dread came back again. Thanks for your continued generosity. Are they allowing in how she exhausted every single option to receive proper care, basically begging and pleading, only to be told, oh, take this pill. We need to switch medicine and increase your dose. That's for sure going to be able to come in. That's
Yep.
for sure, because it goes
100%.
against their whole intent argument. So now I highlighted this. No one attack her. Okay. But Tammy Glass and Nappies, whatever, Nappisman. Sorry, I'm butchering it. I apologize. The children need justice also. Justice is sometimes not charging a crime. Justice can happen without a criminal offense, because when something tragic happens, justice is treating it as a tragedy, responding as a tragedy, making change, maybe, for example, in the boat case and the way the waterways are handled, or whatever the case may be. Justice does not mean
Draft some
a pitchfork.
legislation so that this doesn't happen again.
Justice comes here with this civil complaint. That's the forced justice. That's the forced change. So,
Yeah.
but we appreciate you, and we understand that other people are going to feel that as well.
Yeah. I mean, I don't know which way she's saying it, because I can construe it both ways.
Correct.
I
Maybe
mean,
she did mean it that way.
I mean, but or maybe she meant, throw her in jail and, toss the key out, like, because she did it. I don't care what the,
yeah,
what
you're right.
what the situation is beyond it. But I mean, who knows? I mean, go both ways. And like I said, it's like, Tammy, if you're the former rather than the latter, if you're like, yeah, you know what, the kids deserve justice. She did it. I don't care what the circumstances surrounding it were. She did the act. That's it. There is no lack of criminal responsibility that exists in the world that makes it okay for me to think that she could potentially walk out of a mental health facility in 6 months, right? Like, it's like, I can't stomach that for the kids. And that's a fair thing, but all I would suggest and ask of you is watch the trial, listen to all the evidence,
Stay open-minded.
because, stay open-minded on it, because every case is not the same. This is not Andrea Yates. Every human being is different. We all, like, every case is different. It's like the thing that I always really dislike is when people compare one case to another. No case is the same. No two cases are the same. That's just facts. There's always factual differences in every single case. There always is. And the underlying story is always different. Every trial is a story unto itself. So,
Right.
it's going to be worth checking out. I had flagged one big.
Wait, I got it. Lily B. Let's do this
Yeah.
first. Lily B says,
That
Bob
was
and
the one I
Allie,
flagged.
would you do a bench trial here? I'll answer for me first. I always struggle with a bench trial. Okay. Always, because you need other people. Now, the cases where we have said we have to do a bench trial, and Bob and I didn't take many of these, but it would involve sexual misconduct with children. Because it's like, look, there's not a jury in the world who doesn't hear that and say, nah, just shut down, convict. So and you've got a similar situation here, but it's a little bit different. So all I can say here is I would struggle with it, and I would take, like, Reddington knows his jury pool, he knows his judge, and I would have whatever faith, whatever his team, and if Rosemary's chiming in, is recommending, is where I could go with it here, because there is so much pressure on a judge, like, it's not easy for them to come down on a big case and be like, I'm sorry, not guilty. So I don't know this judge, and if he's the type that will stand up for, like, what he believes in, or
See, and that's the flip side to I don't like that all judges are appointed in mass, but the benefit to that is that you don't have the politics driving judges' decisions on the bench when they're appointed for
Right.
life. You know what I'm saying? Whereas in a state like such as ours, where they're elected, that political pressure exists on them, and they feel that pressure. They hear it, and they may, even though they're not supposed to, they may act accordingly to bend to the will of the people because they're hearing the chatter. I think that doesn't exist in mass because of that. So I think there's, you know, two sides of that coin. You can make the argument that that's a benefit of that particular way of doing things.
But
out
you
there.
still see, at least Bob and I have seen it. Now, do we know for sure? No. But we've seen after certain trials, judges getting, you know, moved around to a different, you know, if you're in the felony courtroom and then all of a sudden you're in the misdemeanor or the traffic bench, like that's like what just happened there? You know,
Yeah.
like sometimes it can be a punishment like that. Like they don't like what you did and this is what's happening. So, but at the end of the day, you know, this one has enough with the mental health that maybe there's more of a, should we just go bench? Because that would be your first instinct. Like,
I mean,
like public can't handle this. They're going to say she unalived these 3 precious babies. You hit a cop.
that's
you're
where
going
I'm
in.
starting in my right. That's where I'm
Right.
starting in my evaluation from that. I'm assuming that the 12 jurors that are coming in there are all, you know, lock her up and throw away the key people. You know, like that's where I'm starting from. So then, as you aptly said, you know, Reddington knows his judge. I am sure that he has tried many cases in front of this judge. Reddington knows his community. He knows his jury pool. He knows what the people are. And you know, I take it as somewhat of a situation wherein I just heard the judge ruling on my motion in limine to bring individuals that have personally experienced these things, and him saying, well, you know, I hear you. I think it's a dangerous path. It's a slippery slope to go there, you know, and what I think is that we're going to have experts who are going to be able to come. Well, I'm holding the judge to that. I'm saying, you know what, judge, you felt that it was satisfactory, that that's enough. And if I've got medical experts getting up there telling you that this is in fact what happened and they can't really challenge it, well, then I'm going to think long and hard about potentially doing a bench, because I mean, look, you never want 1 versus 12. You want that 12 because the numbers, you got better odds of at least getting 1 out of 12 to, you know, cause a mistrial by, you know, going one way or the other. So, but it's a tough call.
I'd be leaning bench, like Bob's saying, from the
I'd be
onset.
leaning bench
I'd be
too.
starting bench, and I'd need to be swayed either
Convinced
by
otherwise. Yeah.
bad rulings by him or like Bob and I've just said. But very, very good question, Lily B. And then lastly, before we move on, I think there was something else you wanted to play. Just south of history says, I hope every woman that wrote into Reddington about this case shows up on the courthouse steps for this trial. Petitioning activity.
Oh yeah. Big time. Big time.
Right.
All right. And then we got 25 from our daily Venmo angel. I didn't have I thought it was tacky to have the Venmo grift up during this particular live, so I didn't have it up. So thank you very much, Kim. We always appreciate it. And before we go,
right.
Mons,
Wait, was there
thank you very
something
much.
else before that you were I thought you had something else you wanted to raise outside of what we're about to do. Maybe not. Maybe I got
well,
mixed up.
I did want to raise. So here's our issue with the trial. We do not know how long the jury is going to take to get selected. It could be a week. It could be longer. Maybe it's less. I don't think so. Allie and I are going on our only vacation the entire summer, and we're gone from Tuesday to Friday. Even if the trial starts, we're going to be airing it here, even though it'll be commentary-less, unless I can jump on for a few minutes
Right.
here and there.
Or let's think about possibly going on to our community page and having volunteers who, you know, sometimes having that 13th juror commentary would be great. So we might consider that. If you want to put your hat in the ring, let's get something on the
And I got a lot of friends in the YouTube world, so I might be able to find a few people to hang out with y'all for a bit. But yeah, I love Allie's idea. I love Allie's idea.
Because I'll tell you something. I am not going to allow him, if I can, although, you know, I say that I can and he pretends that I can, but at the end of the day, I can't, you know, keep him from pushing to go live. We saw it last time. It was our wedding, our daughter's wedding. And I said, he will not. Which trial was that? He will not. But he found a way over that weekend to come on. But this weekend, absolutely not. and we'll see what
Wow.
we'll see if it works out.
She's ruling with an iron fist.
I'm trying.
She's ruling with an iron fist.
Yeah, if Kat's out there, Kat does great. That would be, she'd be amazing. But also, we want
Cat
you guys
would
to
be
throw your
fabulous.
hat in.
Yeah.
Right. So
Yeah.
we want you guys to throw your hats in. So
yeah, Kat's
them,
always like one of my first choices always, because she's our girl, and we
tell
love
them what an amazing special day it is today.
Oh, so today is, well, it was actually yesterday.
Oh,
It
yesterday.
was actually yesterday. And Tracy, our ride or die, our queen mod, seeking justice. And again, everybody go over to that Discord and sub up. It's the greatest document repository for all the criminal cases that you could ever ask for. Every document exists over there. She does an incredible job over there. Plus, they do fun stuff. They watch movies, they watch TV shows, they play trivia. It's amazing. Get over there and sub out. Also, for our mods, please remember that we have buy them a slice of pizza or buy them a coffee, same deal, to help give our mods a little love financially for all their dedication to our channel, for them making our channel such a great place in terms of our community, because it's tough. Like we're not an echo chamber, and we want people to be able to argue and debate their sides, and we don't want everybody just thinking the same way. That's not how we roll over here. And those folks that are doing that for us on a daily basis are the people that make that possible. So give them some love with the buy me a coffee or a slice. They feel it. Tracy doles it out, sends whatever it is to everybody that's out there modding for us, because we love them and we couldn't do it without them. So thank you very, very much. All right. Do you want me to come to you? We're going to do it right.
Before we start to sing, I took off my headphones. I'm hoping that maybe this makes a difference.
It's not going to work. It's the internet. That's the delay.
Right, before we start Tracy's song, I just want to say, I saw what you did in there. You're like, this is our one and only vacation all summer. I'm not knowing that I'm agreeing to that. I cannot believe that I've agreed to that. So we'll
I don't want it to be. It's like,
I know, but
Scout's back in school, like on the 13th. She starts high school. Like when is this happening? It's like mid-July right now. I don't know.
Something could come up. So, I mean, we have to do a trip out to Louisville at some point. That's all.
Louisville.
All right. So what do you think?
You come to me. Come to me.
We should try it. And
no,
then
come to me. We'll double up here. I want to do it right.
Tracy, how do you want it?
She wants it right. She doesn't want it all fucked up. No one wants it fucked up. No one wants it fucked up. Like, no one wants it. Like, she's not going to answer. You're putting pressure on her. Like, she's like, I'm not going to say anything. I'm going to let them figure it out.
All right, I'm going to be
Rebecca. I mean, we agree. It shouldn't be.
You come to me, or I'll be off screen singing.
All right, I'll come to you.
Okay, I'll put back on the microphone. Oh, well, maybe I don't need the microphone. All right, wait. Does my sound just as good right now as it does? Like, all right, I'm going to talk. Happy birthday to, like, so, and now I'm going to plug in the microphone, because I think it'll be easier for us with the microphone off. So now I'm talking with the microphone. Happy birthday. So could you tell a real difference, guys? Wait, give them 5 minutes to say whether the microphone made a difference or not.
5 minutes?
I mean, like 5 seconds, I mean.
Oh, yeah. 5 seconds.
So yes, sounds like the microphone sounds better. Okay.
All right, ready?
Yep. Wait.
And a 1, and a 2, and a 3.
Wait.
Wow.
Oops.
Wow.
We're going.
Wow.
Okay.
All right, there's and a 1, and a 2, and a 3.
Happy birthday to ya. Happy birthday to ya. Happy birthday. Happy birthday to ya. Happy birthday to ya. Happy belated birthday.
We love you so much, Tracy.
We love you,
Thank
Tracy.
you for everything. I hope you had a wonderful day.
Yes.
We love you.
All right.
1,000 kisses, 1,000 hugs.
Thank
all
you
right.
all.
And to y'all, make sure you like, share, subscribe. Please, it's free. We're so close to 70,000. It's killing me. You're killing me. Just sub to the channel, please.
It's free.
If you're replay crew, please make sure to leave a comment that gets it in the algo. And hype it. Hype it. Like whatever, like I think as soon as this ends, like within a couple minutes, hype's available. It gets us into the algo. It does some kind of magical YouTube shit. We don't know. what do we really know?
Right.
But at any rate, we love you guys so very much, because without you guys, I'd just be an old man.
Sitting around talking to his wife.